for admission.
Item
Item number 24
24.
will be left up after 4 weeks, my lord, subject to lordship comments. I'm not keeping
Item
it there.
24 at the request of Mr. M.U. Ahmed, matter stands adjourned for 4 weeks.
Obliged.
Mayor, Your Lordship, I beg to mention item number 102, Your Lordship, on behalf of Mr. K. N. Chaudhary, Senior Counsel, Your Lordship. Kindly, it may be taken as at 2, Your Lordship. He will be not available. Your Lordship.
102 at 2 p.m.
Oblige, Your Lordship.
Yes.
No, please, your lordship, yesterday we filed a missed case in relation to item 60 of today's daily list. That may be called for.
No, why should we call for? Let it be listed on some other date. Item 16.
Yes, lordship.
16 is connected with 13, 14, 15.
No, item
14 and
60,
50.
60.
Huh?
60.
Oh, 60. Item 60. You have filed one more IA.
Yes, lordship.
There is already one IA.
Lordship, there is only one IA, Lordship, because in that IA, we have to file abatement.
So let it be listed on some other date. Why call it now? Let it be listed.
let it be on my lord next week.
Next week. We'll have it on next week. 24th. List on 24th. Yes.
What paper, Lordship? Lordship, I mentioned for adjournment, Lordship, item 35. Other side consent,
Item 35.
35, Lordship. Kindly fix that, Lordship, February 12, 13.
You are mentioning on whose behalf?
Respondent, Lordship.
Respondent who's for the petitioner?
Respondent consent, my lord.
Item 35.
35.
Well, I am for the petitioner.
Ah.
I'll let it be, the lordship will fix a date, my lord.
No, why should we fix a date? It's already fixed today.
Well-
You have given a consent for adjournment.
But he says there is no instruction regarding regularization. Because this is a compulsory appointment in a work charge, agent work charge.
He already received.
How much time do you require?
Salary, their salary.
How much time do you require?
Kitya lagi, one time.
12, 13 February, Lordship.
He says it is, let it be on
12, 13 February.
13 February. This is Monday.
No, 13th is a Tuesday.
12,
Oh, no, sorry, 24.
12,
23 is there. Yeah.
12.
12.
All right, item 35, list on 12.
12.
At the request of learned counsel for the respondent, and which prayer is not objected to by the counsel for the petitioner. 12th.
I beg to mention item number 29, my lord. I am for the petitioner, my lord. Some instruction is required from my time matter. 29, my lord.
Item 29 at the request of Mr. K. Uddin, A.K. Azad.
Azad, my lord.
Matter stands adjourned for 4 weeks.
Please, your Lordship. Lordship, I beg to mention item number 31, Lordship. Okay, matter will continue adjourned for today, Lordship.
31, you're mentioning on
Consent of the
who?
other side, Lordship.
Huh?
I am for respondent number 7 and 8, Lordship.
Where is for the, who's for the petitioner?
It's a Motlep, Lordship. I have consent, Lordship.
Your name, please?
Yan Borua, Lordship.
Mr. N. Borua, learned counsel for the respondent. Praise for adjournment of the matter. He submits the consent of the counsel for the petitioner has also been obtained for. Matter be listed after 3 weeks.
May it be please, your lordship. I beg to mention item number 14, 15, and 16, lordship. Matter may be adjourned for a week, lordship. 14, 15, and 16.
14, 15, 16. You are appearing for all the petitioners. For all the petitioners.
Yes, lord.
14, 15, 16 at the request of learned counsel for the petitioner. Your name?
S.A. Khalifa.
S.A. Khalifa, matter stands adjourned for 4 weeks. Yes.
Please, your lordship. Lordship, I pray for listing of one matter for withdrawal on Monday and another matter, my lord. It's a promotion matter, my lord. 2015, your lordship has heard this matter and has fixed for further hearing this matter.
It has not been listed.
Not been listed.
So
On
the withdrawal matter, you can have it on Monday.
yes, madam.
And the other matter, we'll have it on
Wednesday, madam, or Monday or Wednesday, madam? 24th,
24th.
24th,
No, not on 24th. 5th of February. 5th of February. Yes.
May I please, your Lordship? With the consent of the other side, I would like to mention item 34 of today's daily list, my lord. I am for the petitioner, my lord. My senior Mr. H. Sharma is out of station.
You are for the petitioner.
I am for the petitioner, my lord.
The request of learned counsel, Mr. So-and-so, appearing for the petitioner,
My
matter
lord, may
stands adjourned
take up this matter on last week of this month, January.
for 4 weeks. Yes,
May I please, your lordship? I beg to mention item number 25, my lord. I am appearing for respondent number 5, my lord. I have taken consent from the petitioner.
you are for the petitioner.
Respondent number 5, my lord.
I am for the petition.
Item 25 at the request of Mr.
H.K. Sharma.
H.K. Sharma, learned counsel for respondent number 5, matter stands adjourned for 4 weeks. Mr. H. Sharma, learned counsel for the petitioner, has no objections.
Much.
Wait, Lordship, I beg to mention item number 57. Lordship. Let the matter adjourned for today.
57.
Yes, Lord.
57. It is for orders.
Yes, Lord.
Why are you mentioning it for orders? Why are you mentioning orders matter?
We need some instruction from our client.
57, you're mentioning on behalf of the petitioner.
Lord, yes.
Matter stands adjourned for 2 weeks at the request of Mr.
N. Ali.
N. Ali, learned counsel appearing on behalf of the petitioner. Yes.
Apply.
May I please, your lordship? Lordship, I beg to mention for listing of IA for modification of interim order passed in WPC 6506 of 2023.
Monday.
Bless your lordship.
Yes.
Lordship, for the time being, Lordship. For the time being, Lordship.
No timing.
Briefly dealing with you, Mr.
What instructions have come? Let us see. It was for instructions.
Yes, but as regards the review is concerned, my lord, till now no review order has been passed, my lord.
No.
Though it is under process, my lord, order has not been passed, my lord, and we have already issued a show cause notice to the petitioner, initiating departmental proceeding. Show cause notice was issued on 8/1/2024.
Hmm. All right. We take it up at 2 p.m.
Yes.
2 p.m.
May I please, your lordship? This contempt is preferred against the willful and deliberate negligent non-compliance of the order dated 12/12/22 passed in WPC number 7500, 7550. The order is at page 12. Relevant portion is at page 13, paragraph number 9. The reason,
Page
13,
13.
1-3.
Yes.
Paragraph number 9. The reasoned order be passed within a period of 1 month from the petitioner appearing before the joint director. If the order is in favor of the petitioner, the other respondents are directed to cooperate and do the need. Your lordship, the petitioner appeared before the joint director, annexure B, page 19, and
All right.
submitted her representation.
Issue notice. You are appearing, Mr. Heard learned counsel for parties. Issue notice returnable 4 weeks. Steps on respondent number.
Your lordship, there is only one respondent.
One respondent.
Yes.
Sole respondent. Be taken by usual course and registered post within 1 week from today. Matter to be listed after the returnable date.
Deeply obliged.
Yes.
Wait, your lordship.
Uh.
On the other day, my friend was asked to take instruction.
Yes.
I need some more time, my lord.
Some more time.
I have collected some information, regarding vacancy near Profeta.
You give it to him.
Yes, I will.
You give it to him. Let him find out.
My lord.
Obtain the
Yes,
instruction. Mr. N.J. Khatuniar, learned counsel for the department, school education, prays for further time to complete his instructions. Mr. Haid Sokia appears for the petitioner. Matter be listed after 2 weeks.
Yes, my lord.
Interim order passed on so-and-so be extended till the next date fixed. List on 5th of February.
Obliged.
Wait, please, my lord. My lord, the petitioner is working as a lecturer at Rangsina Senior Secondary School, my lord, at West Kabi Anglong.
There is some contempt petition.
There is a contempt petition pending, my lord. There is an order of this honorable court to provincialize the services of the petitioner, my lord.
What has happened, Mr. Khatun? The order has not been complied with.
Order has not been complied with.
I have to open instruction, my lord, here.
In the meantime, my lord, they've issued the impugned office memorandum, my lord, which is at page 136.
Hmm. Yes.
Lords, I'll not trouble my lordship with the entire office memorandum, my lords. Page 137, clause number 7. The 15 DEO must ensure that non-provincialized teaching staff, non-teaching staff should not be allowed to work, serve in a provincialized school. In future, any such references are found, personal responsibility shall be fixed upon the erring officials. Now, based on this OM, the respondent number 4, my lord, which is the headmaster of the school, principal of the school, is not allowing the petitioner to discharge her duties. She is not being allowed to enter the premises of the school. Now, there is an order of this honorable court to provincialize her services, but that is not being done. And in the meantime,
Where is the order of the court?
my lords, the order is starts at page 115, my lords. Relevant being page 125.
Yes.
Page 125, my lords, para 12. From both points of view, the undated notification of the Commissioner and Secretary to the Government of Assam in the Secondary Education Department, which finds place at so-and-so, to the petition is unsustainable in law. According the same is set aside, and there is a cabinet decision dated so-and-so for regularizing the service of the petitioners, and for the purpose of the OM dated so-and-so had been issued by the Principal Secretary to the Government of Assam in the Secondary Education Department. The respondents are now directed to carry forward and bring the said process to its logical end at the earliest. Para 14 thereafter, my lords, page 126. From such point of view, the requirement of bringing the process to its logical end be done positively within November 2021, so that if any benefit accrues to the petitioner, even the person who would retire by so-and-so may have the benefit of regularization at least for a few days prior to their retirement. Now, they have not complied with this order, my lords. Thereafter, a contempt petition has been filed.
Hmm. Yes.
Now, my lords, contempt petition.
What is the final direction of the court?
Direction is finally to, my lords, regularize their services in terms of the cabinet decision, my lords. Cabinet decision, if I might take my lords to that cabinet decision.
We don't have to look into it. We are just take us through the operative part of the order, the effective part of the order.
Order, my lord. Page 125.
Hmm.
My lords, if I may just place the antecedent facts.
So pursuant to the cabinet decision, there was an office memorandum.
There is an office memorandum. In view of that office memorandum, there was
Where is that office memorandum?
Yes, my lord. That is starts at page 100, my lords. 100. Relevant is at page 101, my lord.
In the cabinet decision, the name of the petitioner was not before the
Not
cabinet.
there. But my lord, there is subsequently thereafter orders have been issued whereby they wanted to bring the petitioner within the ambit of the 2017 Act. Now there, in that very list, the name of the petitioner is reflected, my lord.
Where is that order?
Yes, my lord. That order is at page 110, my lord, 110. This is a notification of May 2017 at page 1112, my lord, 112, page 112. At serial number 46, my lord, will find the name of the petitioner.
40?
Serial number 46 at page 112. Now they took a decision to regularize the services of the petitioner under the 2017 Act. Thereafter, they by an impugn order, my lord, which was set aside by this honorable court in the judgment that I just referred to, my lord, the impugn order being at page 114.
Yes.
The second last paragraph. However, a list of 38 numbers of teachers and tutors were not published out of the list of so and so 97 candidates. 97 candidates being the candidates whose name finds mention in that order that I just showed, my lord. On the ground that the data of the rest of the 59 candidates were not linked with UDICE.
So where is that 38 number of teachers?
That list is not there, but this order was specifically set aside by the judgment in WPC 3816.
This 38 numbers
Yes,
is a list out of this 97.
97.
And this 38, according to the department, the UDICE was found to be recorded.
Yes. Now, yes, man, it was not recorded. And the order that I am
No. It was recorded or not recorded?
They took the contention that because their names were not recorded in the UDICE data, they could not be provincialized.
So they means which group? 59 or 38? 59.
58, my lord, yes. 59.
59.
59.
And the petitioner was a part of this
59.
59.
Now,
So this has been set aside.
set aside. At page 126, my lords, there is a observation made by this honorable court also, my lord, that UDICE will not be made applicable to the petition.
Which paragraph?
Page 15. We have also taken note that apprehensions are being raised by the respondents regarding the information relating to the petitioners not being captured in the DICE code for the given year. The same by itself would be irrelevant in as much as the information to be captured in the DICE code for the given year is a requirement under the provisions of the Act of 2017. Whereas in the instant case, the regularization of the petitioner would be pursuant to the cabinet decision of 2016, which was made even before the enactment of the 2007.
And what is the offending notification now?
The offending notification is, my lords, at page 136. It is an office memorandum dated 26 June 2023.
But it is not with regard to rejection of the provincialization.
No, it is not.
It is with a direction that if they are not provincialized, they should not be allowed to work.
Yes, ma'am. So, my lords, I am not
Okay,
being.
you get your instructions. Heard learned counsel for the
Is there,
party.
my lords, an interim protection, my lords?
Mr. N.J. Khatoniya, learned standing counsel for the state. The writ petition is filed by the petitioner, aggrieved by the. Is there any order passed by the school principal?
No, my lords, I've made a specific averment in the writ petition.
Aggrieved by the refusal of the respondent number 4, namely the principal Rangsina Senior Secondary School, where the petitioner was working as
Lecturer, my lords, in the geography department.
lecturer in the geography department, refusing to permit the petitioner to attend to her classes and other connected works. She is required to perform as a teacher of the said school. Stop. The petitioner was appointed as
Page 26 is the appointment.
a lecturer in the so-and-so school. On which date?
8th August 1997.
on 8 August 1997. Stop. Under the Assam Junior College Education Provincialization Act 1996, 48 numbers of junior colleges were provincialized. The said junior colleges, the said 48 numbers of provincialized junior colleges also included the said Rangsina Senior Secondary School, West Karbi Anglong. Stop. However, in the subsequently, they were deprived from being granted the benefit of deficit system of grants in aid. Stop. This led to filing writ petitions before this court. This court, by order dated 16/12/1999 in WPC 2071 of 1999, disposed of the writ petition with the direction to the respondent authorities to grant the benefits flowing out of Section 3 of the Act of 1996 to the members of the Association of School Teachers. Stop. Subsequently, another writ petition was filed, being WPC 5246 of 2000, whereby direction was sought for to bring 1099 posts of teaching and non-teaching staff under the deficit system of grants in aid. Stop. This aid writ petition was disposed of on 4/12/2000 with a direction to the respondent authorities to take necessary steps for granting the benefit of deficit grants in aid as notified in the government notification dated 2/1/1999. Within a period of 6 months. Stop. That subsequent to the direction, the matter was placed before the cabinet, and the cabinet what happened thereafter?
There is another writ petition, my lord, thereafter, my lord. Para 9, if my lord please. There is
No,
an
when was
order-
the cabinet decision passed?
Yes. Annexure E.
Subsequently, the cabinet granted approval by granted approval for regularization in 48 your facts are not symmetrically laid out.
I have laid out the entire background, my lord.
No, background is okay, but now we are not concerned with the background.
Yeah.
You are concerned with this order, but what happened in the, what decision was taken in the cabinet?
The cabinet decision that
Where
I-
is that?
Yes, my lord, sir, cabinet, the earlier cabinet decision, my lord.
You are referring to a cabinet memorandum which is referred to in the
Annexure E, my lord.
judgment.
Yes, that is at page 91, my lord.
This is the cabinet memorandum.
Yes, my lord, this is the cabinet decision,
No, this
which
is
was
not a,
followed by an office memorandum.
no. This is a cabinet memorandum.
The judgment in, my lord, that I'm relying on refers to this very same cabinet memorandum.
Subsequently, the matter was placed before the cabinet. And with regard to the regularization of the services of the prop teachers in 53 junior colleges in Assam, which included the petitioner. Stop. The cabinet, in its meeting held on 28/2/2016, approved the said proposal contained in the said cabinet memorandum. However, the petitioner's case, the petitioner was still not considered for regularization in view of the absence of the UDICE.
You guys,
Do you call it UDICE or UDICE code?
you guys,
UDICE code.
you guys.
Stop. Being aggrieved, the petitioner and other similarly situated persons approached this court by filing WPC 3816 of 2021, which writ petition came to be disposed of by judgment and order dated 17/11/2021, whereby the decision of the government not to regularize the petitioners in the absence of the UDICE code was interfered with. And the claim of the petitioners, including the present petitioner, was upheld, and the respondents were directed to regularize their services. Stop. While disposing of the writ petition, this court also held that information of the petitioner not being captured in the DICE code will have no relevance in respect of regularization of the petitioners. Stop. The said order not having been complied with, the contempt petition has been filed in the same. It is submitted. It is still pending. Being contempt case number 480 of 2021. Stop. While the said contempt petition, while the matter is situated thus, the impugned memorandum, office memorandum dated 21 June 2023 was issued by the government, whereby the in respect of certain conditions pertaining to within quotes base school, wherein one of the conditions stipulated that non-provincialized teaching staff and non-teaching staff should not be allowed to work or serve in the provincialized school. Stop. It was further stated therein that if any such references are found, personal responsibility will be fixed on the hearing officers. Stop. Learned counsel for the petitioner submits that pursuant to this office memorandum, the respondent number 4, namely the principal of the school, has not permitted the petitioner to continue in her services and has withdrawn her from performing her duties and undertaking classes. Stop. Under such circumstances, the petitioner is before this court. Para Mr. N.J. Khatwaniar, learned counsel for the petitioner, submits that he has no instructions at this stage and craves leave to obtain required instructions in the matter. Let notice be issued. Can you get instructions without issuance of a notice? Because
Notice, my lord.
Huh?
Notice.
Notice.
Yes, sir.
Notice be issued, returnable 4 weeks. Matter be listed after the returnable date. Mr. Khatwaniar appears for the respondents 1, 2, 3, 4. Therefore, notice be waived in respect of those respondents. However, extra copies be furnished within 1 week from today. Steps on respondent 4 by usual course and registered post 80, thusty is also permitted. Meanwhile, operation of the... You are affected by only one clause.
Only one clause.
Operation of the so-and-so office memorandum dated so-and-so, insofar as clause number 7 thereof is concerned in respect of the petitioner, shall remain stayed until further orders. The petitioner be permitted to resume her services in the school.
Deeply obliged.
Obliged, Lordship.
May I please, Lordship?
Yes.
Well, the impugned attachment order is at page number 16 has been issued by the Deputy Inspector of Schools, whereby he has attached the service of the petitioner, who is the serving as head assistant of the Deputy Inspector of Schools, my lord, to a block.
How far is Lokkipur?
It is not permissible, my lord, under law number 1. Number 2, that the Deputy Inspector of Schools has no authority under the rule
On
to transfer
what
such-
basis do you say so?
My lord, the rule is the
Which
my lord.
rule?
The Assam Elementary Education Provincialization Act 1974, Section 4, page number 287 of the Education Manual. It provides the
Education.
Director of Public Instruction
Uh,
shall be the administrative officer on elementary education and shall exercise such powers and perform such duties as may be required for carrying out the purposes of this act.
where is the rule? What is the rule? If you're holding this book, then what is the page number?
On page 287. my lord.
287. Yes,
Section 4, my lord.
section 4.
Director is the administrative authority.
Director of Public Instruction will be Director of Secondary,
Now it is Director of Elementary Education.
Elementary Education. What about the inspector?
Deputy Inspector is a subordinate authority, my lord.
No. Where do you find reference to inspectors?
Inspector, my lord, there is no reference.
You are governed by under which service rules?
This is the, my lord, only, there is no specific, this is the only, my lord.
This is an act.
This is an act.
What is the rules?
The rules are not there.
Huh? What about the 77 rules?
The 77 rules mainly with regard to, my lord, the appointment of teaching staff.
Yes, Mr. Khatwaniar.
Sir, this is not a attachment order, my lord.
I know, he says he is not authorized. Person issuing the attachment order is not authorized to issue. Under what provision?
There is no specific service rule as regards the grade 3 staff, my lord.
Oh, then?
And they are,
How are the services, how are they appointed? On what basis?
Director appoints, my lord. Director give appointments as well as the promotion, my lord. Page
So
number
on what basis if there are no rules? Is there a guideline?
No guideline, I think so administrative practice they are doing.
Then
since my lord, they are grade 3 and grade 4 staffs, my lord, in the office of the Deputy Inspector of Schools. They are by the ministerial establishment, district establishment service, my lord. They are governed by.
You file an application before the authority, let them decide.
We have filed them, my lord.
Where?
It's there, page
Page 18, my lord.
17 by my wife and 18 by the
18.
petitioner.
Before whom?
Director
Before
of
director.
It's not been disposed of.
It is not disposed of.
Okay, Hard Learned Council, we are disposing it of then.
Yes.
Hard Learned Council for the parties, this writ petition is filed by the petitioner, agreed by the, where is the order?
Order page 16, my lord, impugn order.
1/6,
Yes, sir.
agreed by the order
Dated
dated 22/12/2023, issued by the Deputy Inspector of Schools, whereby the petitioner was attached to the office of BEEO,
where there is no post of head assistant.
Lokkipur, Kachar. Stop. The petitioner is working as a head assistant
Yeah.
in the office of the Deputy Inspector of Schools, Silchar. So by the impugned order, he is required, he was directed to hand over charge to the junior assistant and join in the
Office of the BEO Lokkipur.
office of the BEO, Lokkipur, Kachar. Stop. Learned Council for the petitioner submits that under the Assam Elementary Education
Provincialization Act 1974.
Provincialization Act 1974, it is the Director of Public Administration who is the authority responsible for exercising administrative powers under the Act. Stop. Learned Council for the petitioner submits that the Deputy Inspector of Schools is not authorized to issue such orders of attachment or transfer in respect of head assistants like the petitioner. Stop. That apart, it is submitted that there is no post of head assistant in the office of the BEO, Lokkipur, Kachar, where the petitioner has been attached by the impugned order. Under such circumstances, he has filed representations before the Director of Secondary Education. On which date?
On my lord, 2/1/2024. It was sent by post.
On 2/1/2024, and it was sent by speed post. Stop. Learned Council for the petitioner submits that this representation has not been disposed of by the authorities, by the concerned authority, and left with no alternative, he has approached this court for appropriate orders. Madam. Mr. N.J. Khatonier, Learned Council, appears for the department, submits that at present there are no specific rules governing the service conditions of head assistants, grade 3 personnel under the education department. Stop. He craves leave of the court to complete his instructions. Para. Having heard learned counsels for the parties and upon perusal of the pleadings on record, it is seen that the impugned order is an order of attachment of the petitioner in the office of BEO Lakhipur, Kachar, from his present place of posting, namely office of the Deputy Inspector of Schools, Silchar. Stop. The pleadings contain orders reflecting his promotion, reflecting the orders issued appointing the petitioner as LDA, as well as his subsequent promotions, and all these orders were issued by the Director, Elementary Education. Stop. It is also seen that there is a representation stated to have been filed with the petitioner and sent by post on 22
2/1/2024.
2/1/2024, and which has remained pending. Stop. In that view of the matter, this court is of the considered opinion that the writ petition can be disposed of with a direction to the Director, Elementary Education, namely respondents when so herein, to expeditiously consider the claims of the petitioner ventilated through the representation filed and dispose of the same by way of a speaking order. Stop. In the event the Director, Elementary Education is of the view that the impugned order dated so and so passed with the Director of Schools, Deputy Inspector of Schools, is an accept under the rules, then the same shall, then effective orders thereon shall be passed by the Director, Elementary Education. Stop. Any such speaking order that is passed, copy thereof shall be furnished upon the petitioner. Stop. The direction above shall be carried out within a period of 30 days.
Yes.
From the date of receipt of a certified copy of this order. Writ petition stands disposed of in terms of the above.
But in the interim, my lord, till
disposal, the impugned order dated so and so shall not be given effect to.
Obliged.
May I play the lottery? Bishop, I am a regular teacher, my lord. My service has been accommodated as tutor in Rabidas Pada LP School, my lord, by order dated 23rd September 22, NXR 11, my lord. Page 55, my lord.
You are praying for what, salary?
Yes, my lord.
Get your instructions, Mr. Haronia.
Yes.
The writ petition has been filed by the petitioner claiming area salary. For which period?
Bishop, as per accommodation order, my lord. NXR 11, my lord. Page 55.
Which period you are claiming your salary?
1/11/2020.
Where have you stated that?
In page, my lord, 56, my lord, second paragraph, my lord. The accommodation order will take effect from 1/11/2020 only, and she cannot claim benefit whatsoever in respect of post service by prior to 1/11/2020.
You were appointed as what?
Tutor, my lord.
Hmm?
Tutor, my lord.
Tutor. By which order?
Lordship, earlier, my lord,
I heard learned counsel for parties. Let instructions be completed by the respondent. They start in
next
2
set
weeks.
two, my lord.
All right, let him get his instructions. You furnish extra copies.
Most obliged.
You furnish extra copies.
Most obliged.
Yes, Mr. Chaudhary.
I please your lordship, my lord. The petitioners were employees of Amtron. Petitioner number 1 and 2 have since retired, lordship. They joined in service in 89. And in between in 93, board took a decision and gave some increment to the non-technical persons, whereas the technical and non-technical persons were appointed against same advertisement with same pay scale, etc. Then they hesitated. Thereafter, they have come to this honorable court, that is Annexure 1 at page 15, Lordship. There, the court held that this court is not going to interfere in there, and matter was left to the board. As against that, Lordship, the at page 6, Lordship, I have quoted what the court held at paragraph 4, Lordship. Almost the middle. In any case, the Reed Court does not have any power to assess the correctness or otherwise of the policy decision adopted by the respondents for upgradation of the non-technical staff. Be that as it may, it appears that as per the recommendation of the subcommittee, the staff belonging to the technical category, and for that matter, the petitioners have been provided with incremental benefit, and disposed of the Reed petition with judgment dated 7/11/2005 with the direction to the respondents saying, in view of the above, while not granting the relief to the petitioners providing their upgradation at par with the non-technical staff, it is hereby provided that incremental benefits as recommended by the subcommittee and accepted by the board should be extended to the petitioners if not already extended. As against that, Lordship, a writ appeal was filed. Lordship will find that at Annexure 2, page 21. And during pendency of that, the board invited the technical staff representative for discussion. And during the discussion, when the appeal came up, the appellants there, they sought for time, and that time was granted by this honorable court. That is at page 26. The second para, the court is and Decca Learned Counsel for the Respondents Corporation were sought in, and thereafter, if required, both the parties may enter into necessary discussions for resolution of the matter. To enable the parties to do so, if they are so inclined, the case is adjourned for 6 weeks. Thereafter, Lordship, some negotiation was held, and Lordship will find at Annexure 4, 5, and 6, Lordship, at page 26. No, sorry, 27. Pursuant to the discussion, order was passed. I'm reading, Lordship. Consequent upon the approval of the board of the directors in the meeting held on 9th August, so the petitioner number 1, Koilan Boiragi, technician, is granted 2 additional increments. Likewise, all the 3 employees were given 2 increments, but suddenly at Annexure 6, page 30, Lordship, without showing any reason, they have kept in abeyance the former orders.
These orders issued in 2010.
Lordship,
Orders of granting you increment in 2010 has been kept in abeyance.
in abeyance.
Yes, then
And thereafter, Lordship, repeatedly we had been filing representations before the authorities. They keep mum and no action was taken. And meanwhile, the petitioner number 1 and 2 have retired in.
all right, we'll issue notice at this stage.
Sure.
Heard Learned Counsel for Parties issue notice returnable for which Mr. N. Kolita,
Yes, Lordship.
Learned Counsel appears for
Respondent number 1.
respondent 1. Then 2, 3, 4. Any standing counsel? No. Let notice be, let Mr. N. Kolita appears for respondent number 1. Therefore, notices are waived. However, extra copies be furnished. Insofar as respondent 2, 3, 4, and 5 are concerned, steps be taken by usual course and registered post. Stop. Within 1 week from today. Matter be listed after a returnable date.
Time may be fixed, Lordship.
26th of February?
I don't know.
Yes.
Nice. Lovely.
None appears passed over. None appears as a petition. Yes, yes,
Yes, I'll take this matter at 2 p.m.
2 p.m. All right. 2
Alright.
p.m.
Nice.
May I please, Your Lordship?
Yes.
The matter relates to Lordship, wrong calculation of the actual pension and gratuity, Lordship. Petitioner was the retired employee of Master Roll Worker, Lordship. He was retired as helper, Lordship. Lordship, there is an office memorandum, Lordship. That office memorandum, Lordship, may kindly look at page 29, Annexure E. The period of Master Roll Workers regarding 6 years of service, deduction was made, Lordship, on the basis of that memorandum, Lordship. But Honorable Court already held that, Lordship, Annexure Z, Lordship, that a further exercise on the basis of that memorandum is not permissible, Lordship. The relevant portion is, Lordship, page 50, Lordship. The last para, Lordship. May I read the relevant portion, Lordship?
Yes.
This
Oh, this is a part of the judgment.
Lordship. I have
Yes.
already annexed, Lordship, this judgment, Lordship, that is Annexure Z, Lordship. Annexure Z, start from page 30 and I read at page 50, Lordship.
Yes.
May I read para 29, Lordship? Real
Yes.
submission of the parties have been duly considered. The decision to grant pension to casual master roll worker whose services were regularized and have completed 20 years of total service cannot per se be termed as arbitrary. The question which arises for determination is whether the decision contained in the so-and-so office memorandum 25/2029 to
This has
deduct-
been upheld in an appeal also, this judgment.
Lordship.
Subsequently, there is an appeal.
Lordship. But I have not annexed, Lordship.
You
But
have-
There is another office memorandum, Lordship.
Hmm.
On the basis of that memorandum also, Lordship, the pensionary benefit
No,
should be
according to you,
granted, Lordship, without deducting the service. Lordship.
so how many years have you put in? 29 years.
Almost 30 years, Lordship, 29
30
years, 9 months, Lordship.
And then after that, how many years were deducted? 6 years.
6 years, Lordship. I have already got the pension, but actual amount of pension has not been paid, Lordship.
Yes.
Already
Mr.
recovery
Upadhyay.
has also been made, which is
Lordship
also
may
not
issue notice
permissible,
of
Lordship.
detail, Lordship may issue notice of detail, Lordship.
Notice, this is covered by the subsequent
Lordship
judgment.
instruction.
It is covered by this, where there is a direction not to deduct.
Already recovered also, sir, Lordship. That is also not permissible, Lord.
So what notice is required? All right, you get your instructions.
Lord,
You go through, we'll take it up after 1 week, let him get his instructions. Heard learned counsel for the parties matter relates to the grievance of the petitioner is deduction of the initial 6 years as per which office memorandum,
Lordship, Annexure E, Lordship,
page number,
page number 29, Lordship.
as per OM dated 20th of May 2009, whereby it was provided that period of master roll service of initial 6 years shall be deducted while calculating pension. Stop. It is submitted, the petitioner has put in 29 years, 9 months. But his qualifying service was shown as 23 years, 9 months after deduction of the initial 6 years of service. Stop. Consequently, the last pay drawn, the petitioner was reflected as 27,190. And his pension was accordingly calculated on that basis, stopped. Learned counsel for the petitioner submits that a coordinate bench of this court in WPC number 1089, 2015, Sanjita Roy, by the judgment and order dated 4/12/2018, held that such deduction of 6 years while calculating the qualifying period of service is not reasonable and fair. And directions were issued to determine the continuous length of service of the petitioners, which were put in as master roll workers. And if such service meets the benchmark of 20 years without any deduction, the benefit of the pension should be made available to them. Stop. Placing reliance on this order, judgment and order, the learned counsel for the petitioner submits that the deduction of 6 years from the service of the petitioner is contrary to the findings of this court. Mr. N. Upadhyay, learned standing counsel, irrigation, is permitted to complete his instructions in the matter. Matter be listed again after 2 weeks.
Lordship.
Petitioner will furnish extra copy to the writ petitioner in the meantime, after 2 weeks.
But pendency may not be a bar to recalculate.
Tendency of the writ petition may not be a part. Resolve the grievances of the petition.
Yes.
Apply.
Oblige, Lord.
Please, Your Lordship.
Yes.
Lordship, the husband of the petitioner was suspended on by order dated 10/7/2021. So 2001. And penalty was imposed on 16/4/2008 and 28/8/2008. And against that order, the husband of the petitioner prepared a that is writ petition before the Honorable Court, and which was disposed on 8/1/2010. And finally, he prepared writ appeal before the division bench of this Honorable Court, and Honorable Division Bench by its order dated 14/12/2012 disposed of the writ petition and setting aside the major penalty of the petitioner and directed the department for holding fresh inquiries. He pays page 31, paragraph 12 of the order of the division bench. Page 31. May I read, Lordship?
Yes, yes.
In the present case, admittedly, the impugn order dated 16/4/2008 was passed by the disciplinary authority imposing major penalty of compulsory retirement without giving any notice to the petitioner. After the disciplinary authority recorded its conclusion, deferring the findings of the inquiry officer. The above course of action is plainly contrary to the well-established principle of law, as discussed above. In view of the above, the appeal is allowed by setting aside the judgment and order dated 8/1/2010, passed by the learned single judge in WPC number 4827/2008. Reluctantly, the impugn order dated 16/4/2008, passed by the disciplinary authority imposing penalty of compulsory retirement, and order dated 28/8/2008, passed by the appellate authority, affirming penalty are set aside. As a consequence, the petitioner would be entitled to be reinstated to the service. However, the state respondent would be at liberty to proceed with the inquiry by furnishing a copy of the findings conclusion reached by the disciplinary authority, which are different from the finding recorded by the inquiry officer, with reasons thereof to the petitioner to enable the petitioner to submit his representation against such conclusions and finding arrived at by the disciplinary authority before passing any final order in this regard. till such final order is passed by the competent authority as stated above, the petitioner appellant who would be reinstated in service shall be deemed to be under suspension. However, he will not be entitled to any back wages up to today. With the above observation, the direction of the appeal shall. It is okay, Lordship. I already fully satisfied with the order of the division bench. Lordship may see page 33.
Yes.
Order number strange of compliance order order dated 4/12 passed by the Honorable Guwahati High Court in read appeal number 51/Sri Bidut Guha is reinstated in service with effect from 14/12/2012. On reinstatement in service, Sri Bidut Guha shall be deemed to be under suspension as per said order passed by the competent authority in respect of the disciplinary proceeding following due process. During the period of his headquarters shall be at Assam Police Headquarters, Ulubari, Guwahati. Lordship, after that,
Yes.
the inquiry has been concluded, and Lordship may see the page 36. Lord. May I read, Lordship, order by the governor, this is dispute 28 March 2018, Lordship. After long 5 years, Lordship. Whether the departmental proceeding was drawn up against Sri Bidut Guha APS, the then additional SP Nolbari now under suspension file letter so dated 23/4/2002 for gross misconduct of harboring militant and hiding the fact about the militant in his custody. And where Sri Bidut Guha APS submitted his written statement before the defense by this letter dated 10/6/2002 and denied the charge frame against him. Whereas having not been satisfied with the written statement in defense submitted by Sri Bidut Guha APS, and after careful consideration of all aspects of government, decided to inquire into the allegation and therefore appointed Sri Khagendranath Buragohai, IAS Additional Secretary of Government of Assam, Home and Political Department as inquiry officer to inquire into the charge frame against Sri Bidut Buragohai, APS by notification number so dated 2/8/2022. And whereas the inquiry officer, after causing an inquiry into the charges, submitted his report to the disciplinary authority, wherein the inquiry officer concluded that charge of gross misconduct of harboring militant and hiding the fact about the militant in his custody has been partially proved. Now, therefore, after careful examination of the report of the inquiry officer and materials on record, and also in consideration of facts and circumstances of the case, the Governor Assam is pleased to order the minor penalty of withholding of increments for 2 years or till superannuation without cumulative effect, as provided under the Assam Service Disciplinary Appeal Law 1964. The Governor of Assam is therefore pleased to withhold increment for 2 years or till superannuation without cumulative effect, with effect from the date of next increment due to Sri Bidut Buragohai APS and then additional SP Nolwe now under suspension, and the departmental proceeding drawn up against Sri Bidut Buragohai APS are thus finally disposed of, and the period of suspension with effect from 2/3/2013 to till his joining will be treated as on duty for pension purpose, and no further financial announcement other than subsistence allowance received by the officer will be allowed. Lordship, because no fresh charges has been framed, that inquiry has been concluded on the basis of the previous inquiry, which has been started in 2001. And so 5 years after 5 years of the passing of the judgment of the division bench of the Honorable Court, I have been reinstated without giving any service benefit loss. So I am before your Lordship to
You
modify this.
you did not file any appeal.
Because he died in 2020, Lordship, because her wife does not know whether what type of steps he has taken. And Lordship, entire his posting details in page number 39. Because my entire case has been, that is gone in departmental proceeding, and 2008 to
All right,
2000.
we'll issue notice for the time.
Yes, yes,
Third
boss.
Learned Counsel for the parties issue notice returnable 4 weeks. MS M. Bhattacharya, Learned Counts Additional Senior Government Advocate, appears on behalf of all the respondents.
Yes, Lordship, all the respondents.
As such, notices are waived, however, extra copies be furnished within a period of 1 week from today. Let the respondents complete their instructions and file necessary affidavit if so advised. Matter be listed after the returnable date.
Hi, Your
Deeply abide.
May I please, the Lordship?
Yes.
Lordship, the petitioner is working as Lakmanda Lordship. And by order dated 30 December 2023 at page 49. Page 49. He has been transferred from Manikpur Revenue Circle to Boitamari Revenue Circle. Left hand
Yes.
column, serial number 17. Akhil Kumar Roy. He was working under Manikpur Revenue Circle. A new place of posting is on right hand side list. Serial number 5. Akhil Roy, Latmandal, posted at Boitamari Revenue Circle. So accordingly, he joined at Boitamari Revenue Circle. His joining report is at page 51. He joined on 2nd of January 2024. So surprisingly, on 9th of January 2024, BTC authority issued another order, which is at page 52. It is a type copy of the relevant portion. By this order, the Director of Land Records and Survey BTC transferred the petitioner from Bizni Revenue Circle to Tamunpur Revenue Circle under BTC. So my whole case is that I am an employee under the state of Assam, working in the district of Bongaigaon, and all throughout in my career I am working in Bongaigaon district, and BTC authority is not having any authority and sanction to transfer me from one place to another place. Similar kind of
Bizni is under what?
Bizni is under Sirang district under BTC.
So you're already posted there?
No, I am posted and in Bongaigaon.
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 Why is it shown Bizni?
They have shown that I am on deputation on Manikpur and I am working in Bizni.
Any instructions?
No, Your Lordship. Kindly.
Similar is may I submit.
Yes, yes.
Similar issue has been similar order has been passed by the BTC authority, which is at page 38 in the year 2022. Page 38. Similar issue.
38.
Page 32.
30?
38.
38.
38. By in the year 2022 also, the petitioner was transferred from Business Circle to Kolaiga Revenue Circle under BTC. At that time, I approached this honorable court by way of WPC number 761/2022. It starts at page 47.
Yes.
It starts at page 47.
Your grievance is that you are not posted in Bizni.
I am not working in business.
Bizni. You are shown to be attached.
I've been shown to be attached. I am working in I was working in Manikpur Revenue Circle till the order has been passed by the Deputy Commissioner.
Where is that? Which order?
That order I have shown Lordship at page 49.
49.
I was working in Manikpur Revenue Circle. And he has transferred me to Boitamari. I have already joined at Boitamari on 2nd of January.
Manikpur.
So now,
No, by this order at 49, where were you working earlier?
it has been shown, the name has been shown, Manikpur Revenue Circle, Manikpur RC.
Serial number?
Serial number 17.
17. Okay.
Against the name. And I have been transferred to Boitamari Revenue Circle under Bongaigaon district. And I have already joined on 2nd of January 2022. Now again on 9th of January 2022.
No. In page number 49, your your original place of posting was shown at serial number 17.
17 Manikpur.
From there, where were you transferred?
At page right hand side column.
Serial number 5.
Number 5.
5.
Boitamari.
Okay. Then?
Then I have joined. on
This is not under BTC.
No, not under BTC.
Huh.
It is under
Here-
Bongaigaon, in the state of. So
huh.
I have joined there at Boitamari.
Hmm.
Now BTC has issued an order on 9th of January transferring me from Bijni Revenue Circle to Tamulpur Revenue Circle, and they have shown me on deputation to Manikpur. I was not under any deputation under BTC. I was not working as employee of BTC.
Yes,
And
heard,
earlier, this honorable court has passed an order.
heard learned counsel for the parties. Issue notice, returnable 4 weeks. The learned counsel for the petitioner submits that by order dated 30th of December 2023, the petitioner, who was earlier working as a lot mandal in Manikpur Revenue Circle, was posted to Boitamari Revenue Circle. And pursuant to that order, he had joined in the state circle by on 2nd of January 2024. This is the joining letter.
Yes.
2nd January. Stop. However, most surprisingly, on 9th of January 2024, the petitioner was again sought to be transferred to Tamulpur Revenue Circle, showing his present place of posting to be Bijni Revenue Circle, within bracket deputation to Manikpur. Stop. This order was issued by the Director, Land Records and Surveys, BTC Kokrajhar. Learned counsel for the petitioner submits that he is not employed under the BTC territory or area, and therefore the BTC authorities are not competent to issue transfer orders. Stop. It is his submission that by the order dated 30th of December 2023, issued by the District Commissioner Bongaigaon, he was transferred to Boitamari from Manikpur, in which he is already joined and has been performing his duties thereon. Therefore, this order showing him, this order of transferring him to Tamulpur Revenue Circle, showing him to be in Bijni Revenue Circle, both under the BTC areas, is wholly unwarranted and contrary to law. Being aggrieved, he has approached his court. By filing the present writ petition, praying for appropriate orders. Para. MS P. Das Learned, counsel for BTC,
BTC 2, 3, and 4.
appears for
P. Nayak.
2, 3, and 4. Mr. C.K.S. Borua appears for respondent number 5. Mr. S. Dotto for respondent number 1. Stop. Since the respective counsels have entered appearance on behalf of the respondents, notices are waived. However, extra copies be furnished within a period of 1 week from today. Let the respondents complete their instructions and file necessary affidavit in the matter till the next returnable date. Impugned order dated 9/1/2024 shall remain state. Petitioner be permitted to work in his present place of posting, which is Boitamari Revenue Circle, till the next returnable date. List again on 9th of February.
Deeply obliged.
May it please your lordship.
Yes.
This is otherwise a pension matter. I have only one concern here. Petitioner, when the case was filed, she was a very advanced age. I've not been able to contact her. She will be now around 83, 84 otherwise. Lordship can kindly accommodate me for a 7 days time.
Mr. A. Sharma, learned counsel for the petitioner, craves leave of the court to complete his instructions from the petitioner. He prays for a week's time. Prayer is not objected to by the respondents. Therefore, matter be listed after 2 weeks.
Obliged, Your Lordship.
In this case, we need to bring on record my certain document. 1 week time, my lord, pray for somebody.
Mr. S. Chamaria, learned counsel for the Allahabad Bank,
My lord.
submits that you'd like to file an affidavit. This matter was heard at some length.
Yes, ma'am. We have been directed otherwise to produce the document, original file, my lord, that right now I have received.
Lordship may give a short date.
File an affidavit to bring on record certain documents which he submits will have a relevant bearing in the case. Learned counsel for the petitioner does not object to the prayer made. List up to 3 weeks.
Lordship may give a short date. The petitioner is about to retire on 31st of March this year.
He is already retired.
No. Age of retirement will reach on 31st March.
To be listed after 3 weeks.
Yes, my lord, Mr. H. Sharma, my lord, was appearing in this case, my lord. This is a matter where, my lord, the DP was initiated after, my lord, the person, my lord, had retired, my lord. And the issue was whether the governor's sanction was taken, no, so the records with us to be shown.
Made this your lordship. Lordship, thing is that lordship, there were two disciplinary proceeding lordship.
Uh,
And one happened just prior to the retirement of the petitioner, that is by the Panchayat department. And the second lordship, and second DP was post his retirement, that is by the personal department lordship. Now, problem with the personal department is that lordship, under Rule 21 of the pension rules, concurrency of the governor of Assam is required. So as per lordship, this honorable court directed the government to get the instruction to till now that specific instruction. In fact, lordship, I have in the evening yesterday I have contacted Mr. S. Sharma. He did not tell me he did receive or something like that.
Who? H. Sharma?
No, Rishikesh Sharma.
Uh,
That means lordship, the instruction is still awaited. The whether Governor of Assam concurrency has been received or not before issuance initiation of this DP
proceeding.
Yes, post his retirement.
This DP was initiated after his retirement.
Yes, madam.
DP was initiated in the year 22/4/2002, and he retired lordship on
This will
31st.
be available from the records.
Record is available lordship, but I think it was not, this particular instruction is not available in that record.
So it is not there. If it is not there in the record, it is not there.
So lordship, may kindly last chance also, let me obtain that. Let me write a letter one more time.
If in the records of the matter, if it is not there, it is not there. From where will you get the instruction? You will have to develop your arguments whether
that is required.
The sanction is required in I mean, in what form is the sanction required?
Lordship,
That would be your argument if you want.
what Rule 21 says, lordship?
He retired as what? Project director.
Project director. Yes, lordship, project
PRDA.
director.
And this, there were 2 DPs initiated against him.
Lordship.
What happened to the first DP?
First DP, there was no problem. It was initiated by the Panchayat department, lordship. So my brother.
No, concern means?
Lordship, concerning his lordship, while
No, which department?
Panchayat department.
Panchayat.
PNRD.
First DP.
First DP.
While he was in service.
Yes. Yes.
So what was the finding? What was the ultimate finding in the DP?
Ultimate finding, lordship,
Mr. Dotto?
In fact, my lord, the first DP, nothing was done, madam. That was, my lord, it was initiated, my lord, thereafter nothing was done, my lord, it just, my lord, lapsed that way, my lord.
Then second DP was initiated by?
DP, lordship, yes.
After, my lord, his retirement.
By whom? By the same department?
By the personal
personal
department. By the personal department.
By the personal?
Personal department.
And there was an appeal also, they have filed before the same department, that appeal was rejected.
And this entire proceeding, my lord, arose out of, my lord, this entire, my lord, second, my lord, the second, my lord, DP, rather, which are they saying the second DP, my lord, after his retirement, my lord. The first DP, my lord, then, so-called notices were issued, my lord, they did nothing, my lord. In fact, his earlier suspension order was also set aside by this honorable court.
Now, your pension has not been released.
Not been released, my lord. In fact, my lord, there is a
Provisional?
No, my lord. In fact, there a provisional release, my lord. Provisional release, my lord.
6,75,000.
In fact, my lord, there is a direction for recovery, my lord.
Uh,
What had happened, my lord, the allegation is that, my lord, I had appointed an auditor, my lord, for the purpose of auditing some accounts, my lord, and about spent at about, my lord, 6 lakhs, 6 lakhs. My case is that, my lord, we have gained out 3 crores out of that exercise, my lord. But the issue was, my lord, that I did not take, my lord, the concurrence of, or the, my lord, approval of the higher authorities, my lord. That's why, my lord, the DP was initiated.
Lordship, we have filed one affidavit on behalf of personnel department. In our affidavit, everything, how it was been, the whole proceeding of the DP has been stated. And what we have observed, Lordship, no national justice has been violated. He was given ample opportunity, he was being cross-examined, he was allowed to this thing. So there are no lapses in the DP, Lordship. Only thing is that whether governor concurrency was there or not.
In fact, my lord, the inquiry officer appreciated his efforts, my lord, saying that his efforts were, my lord,
Investigator Lordship may kindly fix the matter for hearing, Lordship. We will satisfy Lordship on the point of law, Lordship. Then if after that, Lordship, instead of disposing of today, Lordship.
Yes.
fix a date and let it come for admission only, my lord. Let it come for admission, my lord. Otherwise, my lord, maybe sometime, my lord, in the month of, my lord, February, my lord, first week. 8th February, my lord, can be done. Otherwise, inconvenient to lordship.
Why it is admission hearing? If a matter is to be heard, it has to be heard.
Right.
Then let the matter, why rule was not issued in the matter?
Rule was not issued.
What to have been issued?
Hearing.
Let the matter be listed again on eighth of February.
8th of February.
No problem. No, sir.
At the request of the Mr. C.K.S. Borua, a government advocate, complete his instructions in respect of the
Concurrency.
compliance of Rule 21
21.
of the Assam pension rules, Assam services pension rules. Mr. M. Dotto, and a council appears for the petitioner, matter be listed accordingly. Yes. Your Mr.
KKMD appearing for
KKMD
petitioner
for
number 5 on behalf of Mr. SK Mehta.
appears on behalf of Mr. S.K. Mehdi on behalf of respondent 5.
May I please, your lordship? Lordship, the matter has become infructuous as the petitioner had died long back and his
Yes.
family has.
Your name.
N. Borua appearing for SP Hussain.
Mr. N. Borua, learned counsel appearing for Mr. S.P. Hussain, submits on instructions that the writ petitioner has long expired. And therefore, the writ petition has become infructuous. Accordingly, the same is dismissed as infructuous. On the instructions, taking into consideration the instructions, submissions of the learned counsel for the petitioner. MS M. Bhattacharya for government.
Yes, Lordship.
Your name?
J. Das.
J. Das for Accountant General. Yes, on behalf of R. Ahmed. Interim order, if any, stands vacated. Pending IAs are also dismissed. Yes.
This matter pertains to arrear salary, lordship. What happened, lordship, during the pendency of the writ petition, process has been initiated by the respondent authority, but I have to take instruction whether the outcome of it.
Yes.
Lordship, I am appearing on behalf of Mr. D.P. Bora, Standing Counsel of Health Department.
What do you say?
Lordship, if they want time,
Because whether it is actually disbursed or not, I have no instruction.
If you have no instructions, means it must have been received.
Perhaps, Lordship.
We'll close it.
Because they have not contracted.
Mr. U. Doctor, learned counsel for the petitioner submits that he has no instructions. He needs further time to complete his instructions in the matter. This matter will be listed again on 5th of February.
I would like to.
What is your name?
You Ghosh, Lordship.
Mr. U. Ghosh appears on behalf of Mr. D.P. Bora, Standing Counsel Health.
Lordship, senior advocate leading the matter is no longer available, and we are awaiting instructions from the petitioners in both the matters, Your Lordship, item 19 and 20.
That is not a ground for adjournment. You are there.
Even when the matter is covered case, matter, similar case has been dismissed matter.
Lordship, I've just received the files and I have no instructions there. Lordship, Your Lordship may accommodate some time, Your Lordship.
Some other employees will approach this court and that was dismissed.
You go through the order and tell us.
Lordship may adjourn the matter for.
No, our job is not to keep adjourning matters. Our job is to complete the board.
I've just received the file actually, and I'm not sure if the petitioners want to.
When you appear in the matter, you are expected to know the brief.
Lordship, otherwise the matter pertains to non-payment of area benefits.
That is
Your
what he
Lordship.
says. It has been disposed of. Yes. MS.
S. Sharma Hazarika, Your Lordship.
S.
Sharma Hazarika.
Sharma Hazarika, learned counsel, appears for the petitioner. Where is Mr. Honikor? Appears for respondent 2 and 3, who submits that similar issue has been decided by a coordinate bench, rendered in the judgment and order dated 19/5/2023, passed in WPC 4450 of 2016, whereby the writ petition was dismissed. Stop. Learned counsel for the petitioner submits that she be permitted to peruse the said order and apprise the court of the next date fixed. List accordingly on 5th of February.
Lordship, I am appearing for respondent number 1.
Mr. S.S. Roy appears for respondent number 1. Have you gone through the order?
Yes.
All right. Itu বন্ধ করো, লাগে নি? Problem লাগছে?
May please. But if this petition is for a direction for payment of graduate scale of pay. But if whether his grievance still persists or not, but if that is instruction I thought. Whether these grievances still subsist or not, that instruction I.
You have not received means they have been, their grievances are addressed.
In terms of the petitioner, he has been given the graduate scale of pay, my lord, regular scale of pay, as per ROP 2017.
They have been given?
Yes, my lord. I have received the instruction, my lord.
Is received instructions?
Lordship, that is only, so Lordship, just I'll take one instruction, Lordship will fix it day after tomorrow. Or
list on 5th. As it is submitted by the learned counsel for the petitioner that, as it's submitted by the learned standing counsel that the grievances of the petitioners have been redressed. Mr. B.P. Bora, learned counsel for the, as it has been submitted by the standing counsel for the respondents that the grievances have been redressed. Mr. B.P. Bora prays for some time to complete his instructions. List on 5th. Yes. None appears for the petitioner on call. Passed over.
made. Lordship, here the petitioner was relegated to intermediate scale after being given the graduate skill without any disciplinary proceedings. Lordship.
Yes. Respondents.
I have gone through the matter, but instructions of my client.
Mr. Karunia,
Yes, my lord. I have to obtain instruction, my lord.
what instructions?
Yes, my lord. We have not filed our affidavit also, my lord.
You get the instructions as to the status
Yes,
as
my
on
lord.
date. Mr. Karunia is permitted 2 weeks' time to obtain specific instructions with regard to the issues raised in the writ petition by the petitioner, Mr. P.P. Bora, IPS for the petitioner, list on 12th.
Idiot.
Non-APS asked of it. Non-APS for the petitioner asked open.
27.
27, you're
My lord,
there.
my lord.
Yes.
So the petitioner in the instant case, my lord, they are praying for the grant of the proportionate pension. My lord, the petitioner's husband, my lord, he died, my lord, at the age of 55 years, my lord, and he has served 16 years, 8 months, and 25 days, my lord. And the border employees, my lord, in a similarly situated case, my lord, at page 30. These are, my lord, common judgments passed in a series of writ petition, wherein, my lord, the court has held at the
Page number?
page number 30, my lord, and extra 5.
30.
Page 44 is the relevant paragraph. My lord, fourth paragraph, my lord, page 44.
Yes.
May I read, my lord? In the instant case, all the petitioners, including the husband of the petitioner in WPC 1124 of 23, had completed 10 years of service before their retirement/death. Thus, they are entitled to get proportionate pension as per paragraph 11 and 12 of the judgment and order dated 28/2014, passed in writ appeal number 289/14 and rule 108B of the Assam Service Pension Rules 1969. Thereafter, in view of the fact that the cases of the petitioners are covered by the judgment and order dated 28/14 passed in writ appeal number 289 of 14, the respondents are directed to give the petitioners proportionate pension as admissible as per law. In respect to the petitioner in WPC number 1124, 13, he should be given arrears of proportionate pension which her husband would have received, and she should also be given family pension as admissible as per section 4 of the Assam Services Pension Rules 1969.
besides giving the proportionate pension as applicable.
Yes, what do you say, madam?
Lordship, as per our affidavit filed by the respondent number 5, Lordship,
Hmm.
in page 3, it is still awaited from the government, Lordship, regarding the present status, matter relating to the proportionate pension, Lordship.
But there is there are orders of.
Yes, Lordship.
Then
But this is of 2015 order, but thereafter affidavit has been filed in 2018, Lordship. Until that time, I think nothing has happened. Lordship, kindly.
Nothing has happened means it
Uh,
has to be
Till
compliant.
the filing of that in 2018, Lordship,
uh.
because nothing has been stated regarding after passing of the judgment, what actually has happened. So thereafter, Lordship, after a long time, the matter has been listed today, Lordship. So may I pray for a 10 days time, Lordship, to obtain instruction from the respondent number 1, Lordship, from the government.
MSM Bhattacharya, learned government advocate, submits that the affidavit on behalf of the department was filed in the year 2018. Therefore, present status is in respect. Present status in the matter is not known. She prays for a short date. She prays for some time to complete her instructions. Mr. H. Gupta, learned counsel, appears for the petitioner, lists the matter on 12th of February,
Deeply obliged, Your Lordship.
enabling the government advocate to complete her instructions.
Lordship. Deeply obliged.
Who's for the petitioner?
The matter is pertaining to transfer lordship and no stay order is there, lordship. Perhaps matter has become impracticable.
You will know better. You are the authority transferring him.
I will let it.
None appears for the petitioner. Mr.
N.K. Sharma appearing on behalf of Mr. H.K. Das.
N.K. Sharma appears on behalf of Mr. H.K. Das.
Standing for respondent number 2, 3, and 4.
For respondents 2, 3, and 4. He submits that he would like to complete his instructions. As the writ petition has been filed with the petitioner, putting to challenge the order of transfer, which was issued on 14/11/2019. So, test again after 2 weeks.
Deeply obliged.
Rare is allowed as none for the petition.
May I Lordship? Lordship, matter pertaining regular pensionary benefit, Lordship. So there are on this 9 number petitioner, Lordship. So 8 number petitioner has been obtained their regular pension, Lordship, except the petition number 9, Lordship. He has not been obtained.
Yes, what do you say?
Your Lordship, on the last occasion, Your Lordship, standing counsel for pension, Your Lordship, to obtain instruction.
Who is that standing counsel?
Hemanto Borua, Lordship, petition number 9, Lord.
Who's for the pension department? No one for the pension department? You are for the pension department? Last order says you are supposed to get instructions. We'll take it up at 2. Complete your instructions.
Masalai.
None appears for the petitioner on hold. Matter be passed over for the day. You are appearing MSA Talukdar for the respondent. Number?
Department.
Or?
Pension Department, Lordship.
Pension Department. Anyone else?
Order for the respondent number 5.
Your name?
Bottom Chakma.
Mr. P. Chakma. Appears for
Order. Respondent number 5.
respondent 5. All right. Okay, none appears for the petitioner.
Obliged, Lordship.
List up, passed over.
May it please your Lordship. Lordship, may kindly adjourn the matter for the day. Lordship, on the last occasion, we have made party to Labor Department, but in the causes that is not, his name is not being shown, Lord.
Name is not been shown because
We have taken steps, Lordship.
government will appear for Labor Department. Who is there a standing council?
Standing. Lordship, we should request. 33.
Who represents the Labor Department?
Lordship, we were
Then?
We have served the copies also.
33. Abdul Mateen Borphaya, no? Lordship, kindly fix it on Monday, Lordship.
Not on
Because here no GA is shown, Lordship. That's why we are not been provided with the brief, Lordship.
And first,
MS M. Bhattacharya, learned government advocate. Prays for a week's time to complete her instructions from the Labor Department, who was recently impleaded as a party respondent. Mr. P. Kakoti appears for Water Resources Department.
Question number 4.
MS
as Dev.
S. Dev appears for the petitioner. Prayer made is not objected to and therefore allowed. Matter be listed after 2 weeks.
2 weeks. Lordship, a date may be fixed.
No date. Let them get the instructions first.
Obliged, Lordship.
Yes.
Deeply obliged, Lord.
Yes.
Bad result. In item number 37, we have filed our affidavit matter. I am for the respond number 2. In 36, we have some receive instruction, but not proper to file affidavit matter. So we need some time, my lord.
My lord, there is objection, my lord, because my lord already 2 years for filing, and my lord, in the last occasion, my lord, 8/1/2024, they said that we have already received the instruction.
No, we have received in item number 36, but not proper, my lord, to file affidavit, my lord. So we need some time. In 37, I have filed affidavit, my lord.
What is the issue about?
Matter relating, my lord, the petitioners are serving as a lecturer. Their PhD degree has not been considered, and that is why they have been given the fixed pay.
Because they have taken outside the
And,
state, my lord. The PhD degree they have taken outside the state, my lord. So they are rejected, my lord.
And there is no any law that somebody is taken PhD from outside the state, they cannot be considered.
You are working as what?
Working, my lord,
Working as what?
as an assistant professor
And in
mathematics
which?
in Jagiroad College, my lord,
It's a government college.
government college.
So for your PhD, you have to take permission?
Yes, my lord.
You have taken
Before appointment, we have taken our PhD, my lord. That is why,
before appointment.
before appointment.
No.
It is initially appointed as against the non-sanctioned post. When she working against the non-sanctioned post, he pursued his PhD degree.
Then?
After completion of her PhD degree, he was appointed in the year 2018, my lord. Here, that
In
is
a sanction post.
sanction post.
Hmm.
Sanction post, against sanction post, she was appointed in 2018. That is Annex 15, page 61, my lord.
Hmm.
And as per office memorandum, 61, my lord, that is appointment letter, terms and conditions. May I read, my lord?
Yes.
terms and condition number 1. The proposed regulation is governed as per provision made in OM number such and such dated 17/7/2004. Column
Yes.
Condition 2, the incumbent concerned will be required to qualify in NET SLATE PhD within 2 years. Otherwise, her service will be discontinued, and till then, she will be entitled to get fixed basic pay as prescribed only from the date of joining subsequent to this order. And in the appointment letter, his eligibility is shown as nil. My lord, when she was appointed, she is qualified PhD holder. My lord, and the petitioner was appointed initially in the college against non-sanctioned post in 2001. And as per office memorandum, my lord, that office memorandum annexure 10, my lord, page 47.
Who's for the UGC? Someone has filed an affidavit for UGC.
No, my lord, here not filed, but in item 37, they have filed the affidavit. Exactly similar nature of case, my lord.
Who is for the UGC?
UGC, my lord, appeared in 37, Mr. Samoa. It is, my lord, in, my lord, item 37, my lord. Here one affidavit filed. Here it is stated that as per UGC regulation 2010, it is complied. And as per 2010, my lord, over
That issue, my lord, placed before the verification committee that whether the degree in compliance with the UGC guidelines or not, my lord, that we have not received that information, my lord.
that is, my lord, the PhD certificate also, it is clearly mentioned that the PhD degree which is pursued by the petitioner and issued the awarded the PhD degree, minimum standards and procedure for awards of MPhil/PhD degree regulation 2009. And this is the regulation, my lord, 2010 also. It is, my lord, page 45. Page
No, let us
45,
go to the affidavit filed by the department.
Department in
In the second writ petition.
Yes, my lord.
Yes, please take up that writ petition. Let us find out.
In second writ petition, my lord, the authority higher education, respondent number 2, filed their affidavit in opposition in page 60, running page 66, my lord. It is only saying that it is relevant to mention herein that the writ
On
petitioner.
what basis are you saying this is outside this state, means not recognized? On what basis? As per what regulations? In your affidavit, para 10,
My lord.
it has not been recognized that it is outside the state of Assam.
Yes, my lord.
On what basis are you making this statement?
No, under the UGC guidelines, my lord, it is mandatory to under the UGC guidelines, my lord.
Where are they? Where are the guidelines?
Today, not with me, my lord.
Guidelines, my lord, in the affidavit filed by the UGC, my lord, that is last page, they
No,
annexed.
where is the UGC standing council? Call him at 2 o'clock. We'll take it up. At 2 p.m. UGC Standing Council. Or you, if it's not available, you get the guidelines.
My lord.
At 2 p.m.
Is the guideline, my lord, available, madam?
We'll take it up at 2. Let
lord,
us have it in
my-
the presence of the Standing Council.
My lord.
Please inform him.
Lordship, on last occasion, Lordship has directed me to obtain instruction, Lordship. Accordingly, I have taken up with the authorities. But till date, nothing has been communicated to me, Lordship, even though I personally contacted them, Lordship.
Which authority?
PHE, Lordship.
PHE does have a Standing Council.
Yes, Lordship.
Who is
But
the
on
Standing
last
Council?
occasion, Sami, our additional AG, he appears, Lordship.
Please verify whether instructions may have been sent to the Standing Council.
Lordship.
You may have asked for it, but they may not send it to you. They may have sent it to the instruction.
Lordship, I have personally contacted them also, Lordship, even though they have not sent it to me, Lordship.
No.
Okay, I shall, Lordship.
Standing Council.
Okay,
Please inform them to be
Lordship.
present in court at 2 p.m.
okay, Lord.
Yes. None appears for the petitioner on call, Ms. P. Das. Learned Standing Council appears for
I'm
the.
appearing with item number 47.
Yes, tell us.
Lordship, as per last order, Lordship, BTC.
Some instructions were sought to be furnished. Yes.
Your Lordship, in this case, Your Lordship, B. Chaudhary is appearing.
So
So, Kali matter may pass over for time being, Your Lordship.
at 2.
At-
At 2 p.m.
Deeply obliged.
Matter will pass over for time being. I will consider Mr. HK Tasik on next Lordship.
At 2 p.m.
Lordship.
What is this matter?
Lordship, matter is pertaining to non.
Any instructions, Mr.
Well, we have filed a No, Lordship. Things are complete, Lordship.
We have filed a affidavit, but as per the affidavit, my lord, it is the finance department, my lord, who will have to take the final call. Who is not a party in the present proceeding, my lord.
They are not a party.
Taken up at 2, Lordship.
At
I will
2
point out, my lord, yes.
At 2 p.m.
There is a note with my lord.
Okay. Mr. Porter. Yes.
Lordship, this case, your lordship, relates to petitioners, your lordship, non-consideration of petitioner's prayer for transfer, your lordship. What has
Huh?
happened, your lordship?
Transfer.
What has happened, your lordship? He initially applied for transfer. If your lordship comes to page 29. Your question.
Instruction, please. Your Lordship, instruction has received, Your Lordship. Since he's not completed his 10 years, so Your Lordship, on that ground, Your Lordship, his prayer has not been accepted, Your Lordship, rejected. I would like to submit it.
10 years.
10 years, working 10 years service has not been completed.
He is working as what? He is employed as what?
Employee is subject teacher, your lordship.
Subject teacher.
Subject teacher.
He is asking for a mutual transfer.
Not for a mutual transfer. He is asking for a transfer to a vacant post at Jorhat, your lordship.
Why?
Because your
Where is
lordship,
he? Where is he posted?
He is Borpeta, your lordship.
Then?
Now his family, your lordship, reside in Sibsagar, your lordship.
So
he initially applied for Sibsagar, your lordship.
transfer on his own request.
Own request, your lordship.
Okay.
own request.
You consider and pass orders.
Your lordship, his working time period is not completed.
On what basis? Where have you indicated the time period?
Your lordship, for that, your lordship instruction has received, your lordship.
The instruction.
In the act, your lordship, there is a provision, your lordship, to that effect, your lordship. In section 7, your lordship, inter-district transfer norms of this particular
is
act.
secondary education.
Secondary education, not in the secondary, this act, your lordship. Assam Elementary and Secondary School Teachers Regulation and Posting and Transfer Act. Your lordship, they let them file an affidavit, your lordship.
Is it available here?
I have a copy, your lordship, may kindly go through this.
It's not available here.
Section 7, your lordship, there is a provision of 10 years continuous service. Let me go through it, your lordship. Later may come up some other day.
I heard learned counsel for the parties, MSP Das learned standing counsel on instruction submits that the claim of the petitioner seeking transfer on his own request to a vacant post in Jorhat from his present place of posting in Borpeta cannot be accepted in view of the provisions of Section 7. In view of the provisions under Section 7 of the Assam Elementary and Secondary School Teachers within bracket Regulation of Posting and Transfer Act 2020. Stop. Under Section 7A, a teacher working in a district continuously for 10 years or more can apply for transfer. Stop. MSP Das, learned standing counsel, submits that the petitioner has not put in 10 years or more as required under Section 7. Therefore, his case cannot be considered. Mr. S. Borthakur, learned counsel for the petitioner, submits that he be permitted some time to complete his instructions, and with regard to the statements, submissions made by the learned standing counsel, matter be deferred. Prayer made is allowed. Matter be deferred for 2 weeks.
Deeply obliged.
You take back your instructions.
Deeply obliged.
এখন কপি এটা করি ফাইলটা রাখি দিই নোট হয়ে গেল এডুকেশন আর instructions to bring.
Please, your lordship. My lord, the petitioner is entitled for higher pension, but she has been paid lower pension by deducting the, my lord, length of service of her husband, my lord. Petitioner husband, my lord,
6 years.
my lord.
How much has been deducted?
My lord, let me see, my lord, pays my lord 55, pension payment order. Operating part, my lord, pays 58. Date of appointment of her husband, my lord, clause 5, my lord, in a table, 25/1963. Pays 58, my lord.
Yes.
My lord, 25/1963, date of appointment. Date of retirement 30/11/1999. Then my lord, next, my lord, the row, my lord, column, gross service, my lord, 36 years, 6 months, 10 days. Non-qualifying service, 12 years, 9 months, 20 days. So 12 plus 9 months, 20 days deducted. And that's calculated, my lord, serial number 7, 23 years, 8 months, 25 days only, my lord. Which is, my lord, contrary to the judgment of the honorable, my lord, division bench judgment, my lord.
He was working as what?
My lord.
He was working in
My
which
lord, working as my lord, office assistant, my lord.
office assistant?
My lord, initially, my lord, LDA, then my lord, office assistant, my lord, as retired. Kindly see, my
Contrary
lord,
to which division bench judgment?
my lord, kindly see page 23, my lord.
23.
My lord, 23. My lord, 145, 2009, my lord. And the petitioner's husband also approached before the honorable court by filing, my lord, the WPC number 4239, 2009. All these cases are, my lord, taken together along with the, my lord, WA, my lord. Kindly see the page, my lord, the page, my lord, page, my lord, 42. My lord, serial number 142. Sri Annaram Dakwa, the husband of the petitioner, my lord. And the operating party is page, my lord, page 50, my lord, of this judgment. Page 50.
50.
My lord, 50, my last sentence, my lord.
Yes, read.
We are therefore of the considered view that the benefit of the provisions of the Act, including those for pension and other retirement dues, would be available to the provincialized employees in service on and after 1/10/1991 on the basis of the length of their service reckoned from the date of their initial appointment. From their initial appointment, that is mean, my lord, when he entered into the service till the date of his retirement, my lord. Then, my lord, this judgment was, my lord, challenged before the Honorable Supreme Court, my lord. Page, my lord, 52. The SLP was dismissed, filed by the state, my lord. Then, my lord, page 53, my lord.
Yes.
Page 53, my lord, notification was issued pursuant to the division bench judgment. My lord, para 2, my lord, page 53. Now, in terms of judgment referred above, the governor of Assam is pleased to order that the benefit of the provisions of the Assam Panchayat Employees Provincialization Act 1999, including those for pension and other retirement dues applicable to the state government employees, would be available to the provincialized Panchayat employees who are in service on or after 1/10/1991 on the basis of the length of their service reckoned from the date of their initial appointment in the service of Panchayat. That is, my lord, when he entered into the service, my lord. That is, my lord, in he entered in, my lord, 1963. My lord, then, my lord, your lordship come to page, my lord, 62. In a similar situation, my lord, where the service period was deducted, one employee, my lord, approached before page 62, my lord. In this case, my lord, honorable court considered by considering the, my lord, division bench judgment, para 9, my lord, para 10, my lord. Para 8, 9 and 10, my lord. Page 64, my lord.
Yes.
Then, my lord, some other cases also disposed of in the same line, my lord. I have their judgment, my lord. All the court, my lord, considered the same view that the total length of service is to be considered, my lord. May I please refer to judgment, my lord.
Yes. Yes.
Para, my lord, para, my lord, 6-7. Deduction was set aside and, my lord, directed to counted the whole length of service, my lord. That is on, my lord, 2/11/2062
Yes, yes.
till the date of his retirement.
Yes, Mr. Counsel.
In view of the considered view of my lord, taken by the division bench, my lord, in the judgment cited by my learned friend in the writ appeal, my lord, 145/2009, 145/2009, and also taking into account
In fact, at page 58, the PPO, it is clearly mentioned that the date of initial appointment was 25/29/1953. Suppose, my lord, the petitioner is entitled to the benefit.
Is it, do you agree that it is covered or not?
It is.
It is covered, yes, all right, I'll dispose. Need to get a black mark for that inside. Red flag. Pink. Yet. Disposed. Yes.
Kindly oblige, Your
disposed.
Lordship.
To keep on until I. Right.
Look, the small issue involved herein is that
This we had fixed it at 2 p.m.
I'm
Huh?
sorry.
He has come, my lord. Can it be on a hearing day, my lord, on Thursday or so? Affidavit we have already filed. Affidavit of pleadings are exchanged already.
Pleadings are complete, my lord.
Well, pleadings complete. Then we'll issue rule.
Lord, these are retired persons.
Pleadings complete, matter be listed
Maybe
again,
taken up on
for admission here
Thursday.
on 20 February.
20 February.
Well,
fine.
The petitioner may file rejoinder affidavit if so advised in the meantime.
Deep.
Yes.
May it clear. Lordship, I am appearing for respondent number 1. Lordship, I have filed my occurrence number yesterday. Lordship, I will file my response. Maintainability and
Respondent 1.
1.
All right.
The last
The
occasion
termination-
also, Lordship, time was granted to them, Your Lordship.
No, Lordship, last time I had instruction to appear. Yesterday I have filed occurrence number.
Your appearance was already recorded.
Yes, Lord.
The fact that you have not filed the wakalat is your concern. Last order we had already recorded.
Lordship will give a short date. I will file my response.
What is the issue here?
Lordship, a challenge to termination order given by an NBFC. There are recent judgments also. It is not a state, neither falls under the definition of other authority. Therefore, on the first order 24/5, the maintainability of the petition was also kept open. In 2023, there is a judgment 2023 for
All right, you file it. Mr. DP Bora, BP Bora Learned Counsel, BP, for the respondent number 1, submits that you'd like to complete his instructions and file necessary affidavit if so advised. Mr. S. Ahmed appears for the petitioner. List the matter after 2 weeks. 2 weeks.
May it please your lordship, my lord. I had filed my affidavit on 12/1/2024, my lord. That record is not here, my lord.
Huh?
That affidavit is not in the record, my lord.
My Lord, that is one part. But
And-
the case relates to non-payment of retirement benefits. And I am waiting since 2020 for my retirement benefits. In their affidavit, they say,
No, but that affidavit is not here.
my Lord,
That is what we'll have to get it on board now. MSRS Dewry Learned Standing Council Soil Conservation submits that he has filed the affidavit on opposition
On 12/1/2024.
on 12/1,
Yes, ma'am.
2024. However, the same is not available on record registry to verify, trace out and connect the same to the case court by the next date fixed. Mr.
A.
A.
Bhattacharya.
Bhattacharya, Learned Counsel appears for the petitioner. List on 19th? 19th February.
In this case, notice was issued on 4/12/23, but no affidavit has been filed by the respondent. That pertains to transfer order. Initially, transfer order was passed in favor of the petitioner, and subsequently denied. And in the meantime, I approached before this honorable court, and this honorable court passed an interim order, kindly see page 57.
57. Yes.
Operative portion 59, my lord.
Second.
Tendency of the recipient shall not be a bar for the respondent to the effect transfer of the debtor indictment rendered by upon the in terms of 7(2) Roman 11 of the aforesaid rule. And thereafter, my lord, the inspector of school passed the impugn order, my lord. Kindly see page 60. And whereby cancel the earlier transfer order, my lord, during pendency of the repetition.
Which this writ petition?
My lord, no, earlier, item number 54, my lord.
And what interim order was passed there?
My lord, in the earlier case, my lord, that respondent stating that, my lord, the appointing authority is
There was
not
no
the-
stay. There was no stay order.
There is no stay, my lord. Initially, impugned transfer order was passed, my lord.
So the earlier writ petition has become infructuous, essentially.
But I praise, my lord, for implementation of the transfer order, my lord.
No, implementation is okay, but it has been cancelled.
Cancel, my lord, during pendency of the petition, my lord. In item number 54, I challenge that. my
Yes,
lord,
any
impugned order.
instructions, standing
Yes,
counsel?
Your Lordship.
What instructions? Read it to us.
Your Lordship, the Assam Elementary, that has been appointed, Your Lordship, secondary, as well as the Assam Elementary and Secondary School Teachers, regulations of posting and transfer rules 2022 do not provide any provision of transfer of a regular principal of government provincialized secondary school, Your Lordship. Then thereafter, Your Lordship, the said act and rules provides provision of transfer to the teaching staff of government and provincialized secondary schools only. And moreover, Your Lordship, the district level committee is the sole authority, Your Lordship, in case of intra-district transfer of teachers.
District
And-
level or state level?
Yes, your district level, Your Lordship. DLC. And in this particular case, the name of the petitioner of Shri Trolekya Chaudhary, who filed online application for transfer as regular principal of Kamarkusi High Secondary School, Kamarkusi School, was recommended by the DLC Committee on Transfer of Teachers, Borpeta. Then thereafter, Your Lordship, the Inspector of Schools, Borpeta, has been requested for placing the matter before the DLC Committee, Borpeta, to revisit the recommendation and thereafter to take necessary actions, Your Lordship, as per rules and procedure by this office letter number so and so. This matter has been placed before DLC, Your Lordship.
Rejected. Item number 50.
23.
Legal
Eight-
and
Oh.
rejected.
Yes.
It was, Your Lordship, he had showed the annexure 13, Your Lordship, which has been
Rejected.
rejected on dated 11/10/2023. And my, Your Lordship, my instruction is on dated 3/10/2023. So I have to obtain fresh
No,
instruction.
what rejection?
Rejection stating that,
DLC.
my lord, that
Yes,
as
Your
per
Lordship.
rule, my lord, the principal, there is no provision of transfer.
Rule,
DLC.
under what rule?
Rule, my lord, Assam Elementary and Secondary School Teachers Regulation and Posting Transfer Rule 2022, my lord.
Where are the rules? Do you have a copy of the rules?
My lord.
Give us a copy of the rules.
I have no million of your age.
It is the state level committee. Why do you say district level committee?
Your lordship.
It is as per the act, it is the state level committee who is the competent authority for recommending inter-district,
Intra and intra, my lord.
huh?
Within the district, my lord.
Inter-district.
My lord.
This is intra.
Intra, my lord.
Intra district.
Within the district.
Where under the rules does it say that principal is not available for transfer?
Initially, my lord, IS stating that he is not the appointing authority. And subsequently, IS passed the order my lord, stating that there is no provision of transfer, my lord, as per the rules for 2022, my lord.
You are the principal.
Principal, my lord.
Now, how can you be transferred? Who will be appointed in your place? In your place, when you go, there will be a vacancy.
Vacancy.
Who will be appointed?
By the director, my lord. IS that
You want to
regarding
go.
health problem, my lord.
You want to go and transfer to a particular school
School, my
where
lord.
there is a vacancy.
Vacancy, my lord. Is nearer to my residence, my lord.
Oh, nearer to your residence.
My lord, because my lord, I am my lord, suffering so many diseases, my lord, and my wife also some diseases, my lord. Kamargo Higher Secondary is far my lord, more than my lord, 50 kilometers than my residence, my lord.
Is there a specific bar under the rules? Any bar under the rules that is not open for principals? Yes, madam.
No, your lordship, because already what they have stated that thing.
What thing?
That your lordship, before the DLC, his matter has been placed.
Where
And
is the
it is the
DLC?
sole-
Where is the
sole
DLC report?
authority.
Where is the DLC report?
That I have to obtain it, your lordship. I don't have.
Why do you come with half instructions? Come with full instructions. You are a counsel. You are assisting the court. When somebody gives you an instruction, your obvious question would be to what would be the follow-up instructions after that? What steps have been taken? You produce it by by 2nd February. Ms. M.S.P. Das, Learned Counsel for the petitioner, submits that she has not received complete instructions in the matter. She prays for some further time. Mr. Padgiri, Learned Counsel for the petitioner, submits that as per his instructions, the DLC has rejected his prayer for seeking intra-district transfer. If that be so, let the minutes of the DLC also be placed before the court on the next date fixed, along with a copy of the relevant act and the rules on the basis of which these transfers are sought to be effected. List on 1st of
Second.
2nd of February.
Deeply obliged.
Lordship, this matter relates to the release of arreared salaries here, Lordship. Lordship may kindly see Annexure 16, page 51 here, Lordship. This is the statement submitted.
Yes, Standing
regarding
Council,
career pay and
School
allowance.
Education, Instructions. No instructions. No instructions.
No instruction, my lord.
Mr. N.J. Khatoniar, Learned Standing Council, Secondary Education, prays for further time to complete his instructions. Mr.
R. Chaudhary.
R.
A. Chaudhary.
R.A. Chaudhary appears for the petitioner. The list after 3 weeks.
Like,
Preparing for respondent number 3, my lord. Already, my lord, the authorities, my lord, released that, my lord, amount, my lord.
Yes.
Lordship, we have received the error amount. Lordship, my humble prayer is that they may be kindly directed to continue the payments in future also.
My lord, it is obviously, my lord. Taking enhanced substance allowance, my lord, after 3 months. And accordingly paid, my lord, as per my instruction, my lord. Until now, he regularly received, my lord, regular.
You are still under suspension. Is he under suspension?
Suspension, my lord.
It is submitted by the counsel for the petitioner that the area subsistence allowance has been credited to the petitioner and he has accordingly received the same. Stop. In that view of the matter, that being the limited prayer on the writ petition, the grievances having been redressed, there is no further cause to pursue in the present writ petition. Mr. E.R. Patgiri appears for respondent number 3.
My lord.
And Mr. Who appears? Anyone
Higher
else?
education, my lord.
Huh?
Higher education.
Higher education. Who is for higher education?
P. Mohanto. MS P. Mohanto.
P. Mohanto.
Yes.
Appears for higher education. And Mr. Gugoi for finance. Respondent number 4. Writ petition accordingly stands closed in view of the taking into consideration the submissions made by the respective councils. The respondents are expected to continue to release the subsistence allowance of the petitioner as per provision of law during the currency of his suspension. Writ petition accordingly stands disposed of. Interim order, if any, stands vacated.
Obliged.
Last occasion, my lord, AG was to provide certain instructions as regards payment. And as per my lord, this PHC, my lord, that if my lord recalls, a checklist was asked for, that has been submitted. And my lord, judicial department was moved, it is not replied
Yes,
till now.
AG.
Yes, no.
Addition, you have already issued pay slip.
He was granted 139 days of leave pay. I told you, no?
From 1/5/2020 to 16/9/2020.
So you make the payment, release the payment now.
Yes, it will be released, madam.
Yes.
But interim amount.
It is submitted by Mr. R. Ahmed, learned standing, standing counsel for Accountant General, that on instructions that pay slip has been issued by the Accountant General in view of the sanction of the earned leave by the PHE department in favor of the petitioner's husband for a period of 139 days with effect from 1/5/2020 to 16/9/2020 by the department's order dated 5/1/2024. So the amount required to be released by the department is also and a copy of the payslip is also enclosed to the said instructions, which has been placed before the court. We'll keep it on record. In that view of the matter, the department is now expected to release the amount as per the payslip.
It will release.
Now, what is the next step to be done?
Next, my lord,
taken?
it has gone to judicial department as per the checklist. My lord. They have to endorse the file, and my lords, we have given all the requisites.
Yes, who's for the government?
Dhoda.
Mr. Dhor?
Judicial department.
Please update the court on the
Proposal by Mr. Pandit.
on the steps taken.
I'll give him the file noting is there, number is there.
On the status of the any endorsements or orders passed for creation of a supernumerary.
Yes.
It is to be created. Why it is only for an opinion it has been sent perhaps.
No, my lord, this will require some,
Created by
this
the
will,
personal department.
and this will, my lord, some financial implication will be there. All calculation has to be done as per requirements. We have sent it to judicial endorse and send it to back to personal.
Please get the instructions in respect of the status of
Personal has no objection.
creation of supernumerary post.
Personal is no objection. Personal is passed. Personal passed, financial passed.
My lord will pass an order, my lord, I will get the.
Right, thereafter, Mr. R. Dhor will also obtain instructions with regard to the status of the creation of the supernumerary posts, which is required to be status of the process, status of the process for creation of the supernumerary post as per the proposal put forward by the personnel department.
No.
Who has sent the proposal? Department.
PHE has said, my lord.
As per the administrative department, which is the PH.
Judicial.
Let these instructions be placed again before the court within 2 weeks. List on 12th.
So my lord, I am
Mr. So-and-so appears for the petitioner. Yes.
This from the judicial department.
You get from judicial as well as finance as well as personnel, whoever is there.
Personnel has forwarded the file, no objection. Finance has passed, always the judicial.
Very well, get it.
My lord, may kindly see the running page number 121 of my affidavit dated 3/1/24.
Running page?
Yes, running page.
Page number?
121.
121.
121.
Mm.
Here, Lordship would say, first, Lordship may kindly see page 120.
Hmm.
This is the dismissal order of the Honorable Court. When the matters were called on 2/11/21, we recorded that none appeared for the petitioners. On the same day, an observation was also provided that in the event none appears on the subsequent call, adverse order shall follow. On 9/11/21 also, when the matters were called, none appeared for the petitioners. But the court deemed it appropriate to give a further opportunity to the petitioners to appear on the next call by again providing that if none appears for the petitioner, adverse order shall follow. Today, when the matters are called, again none appears for the petitioners, the matter is dismissed for non-prosecution. So Lordship would see here three orders, 2/11/21, 9/11/21, and last dismissal order 11/11/21.
So where is the matter listed on?
Yes, now
11?
we see page 121.
121, yes.
That is the cause list, that is 2/11/21.
Hmm.
On that day, case was not listed. This is the cause list. Nor our names were shown anywhere.
This is the daily cause list.
Yes. Of
Is
that-
there a supplementary cause list on that
Yes,
day?
supplementary we have also annexed.
Where is that?
That may be see page 127. Then the order cause list that is 9/11/21.
So why was this, okay, the matter was dismissed.
Yes, that
Matter
is-
was dismissed.
Yes, dismissed. But our names were never shown in the cause list, nor the case was listed. Now,
Hmm.
we filed two petitions. One is for condonation of delay, another was for registration of the writ petition.
Hmm.
The condonation of delay petition has already been allowed.
Hmm.
That may be kindly see page 140. Operative portion.
Yes.
In view of the aforesaid determination, last para, page 140. The ratios shall equally be applicable when an application for registration of a writ petition is filed, which was dismissed for non-prosecution. Therefore, the present application filed under section 5 of the Liberation Act is having no requirement in as much as the writ petition dismissed for default can be registered by court in a given facts of a case in exercise of its extraordinary jurisdiction and on the pair of the party aggrieved. And for such purpose, there is no mandatory requirement to strictly follow the provisions of order 10, rule 10 of CPC. With above observation, the present IA stands closed. This IA was for condonation of delay. So that was allowed. Otherwise allowed, citing certain observation, the Honorable Supreme Court as well.
All right, allowed, yes. Now?
Now, this is the registration petition. So that may can be restored. The main writ petition may be restored.
Anyone for the respondents? Any objection?
No, I leave it to the
Heard learned counsel for the parties, this, this, is it miss case? Miss case is filed, seeking restoration of the writ petition number so-and-so. which came-
6786.
Which came to be dismissed for non-prosecution by order passed by this court on 11/11/2021. Stop. Where is the 9/11?
9/11, yes.
9/11?
Yes,
9/11.
130.
130 is supplementary.
127.
127.
Sorry, 128.
128. 9/11.
9/11, this is regular list and that is supplementary 130.
It was listed for what? It was supposed to be listed for under what column?
Actually, the state was asked to file affidavit. They did not file.
It's for admission, motion, hearing.
As it is not shown in the cause list, so I have no idea.
Now, on 2/11,
Yes,
matter as you say was not listed.
not listed. From the cause list, it appears so.
Oh. Okay, by the said order, The writ petition was dismissed. Stop. The order dated 11/11/2021 is extracted below. Extract the order. Para. Mr. M.U. Mahmood, learned counsel for the petitioner, submits counsel for the applicant, referring to the cause lists enclosed to the present miss case, submits that the matter was not shown to be listed in the cause lists for the daily cause list of 2nd November 2021, as well as for the supplementary cause list of 2nd November 2021. Stop. Similarly, on 9 November 2021, also the matter was not reflected in the cause list, both in the daily as well as supplementary cause list. Stop. In that view of the matter, the petitioners and the counsel engaged was not aware of the matter being listed, and consequently, there was no occasion to appear before the court on the say given date. Accordingly, the writ petition, which was dismissed for non-prosecution, appears to have been passed. The order appears to have not been accordingly, there was no fault on the part of the petitioner or his counsel in not representing the petitioner before the court on the said date, as the said matters were never listed before the court. Under such circumstances, he submits that for the interest of justice, the impugned order be recalled and the writ petition be restored to file. Stop. There are Mr. Pegu, learned counsel appearing for elementary education, does not object to the prayer made. Stop. Having heard learned counsel for the period, for the parties, and upon careful perusal of the miss case, it is seen that for the cause lists on 2nd November 2021, in the daily as well as the supplementary cause list of 2nd November 2021, the writ petition WPC 6786 of 2017 within bracket Hafizur Rahman versus State of Assam and others is not shown to be listed. Similarly, the daily and the supplementary cause list of 11/11/2021 also does not reflect that the said writ petition was listed before the court on the said date. So under such circumstances, we find sufficient force in the submissions made by the learned counsel for the petitioner, and it appears that the matters were not listed on the said date as reflected in the cause list, and therefore the order dated 9/11/2021. Sorry, 11/11/2021. Yeah. Now, what about 11/11?
Yes,
That is
11,
also
I have also annexed that may be seen, my lord.
Then you write again,
Yes.
again on the 11/11/2021, the matters
Yes,
were not
that
shown to
is-
be listed.
11, my lord, may kindly see page 132.
Any supplementary list
Yes, that is 134.
on so and so date, the matter was also not shown to be listed. Under such circumstances, the impugned order dated 11/11/21 dismissing the writ petition for non-prosecution stands recalled. The writ petition 6786 of 2017 is restored to file. This case is accordingly allowed and disposed of. Registry to list WPC so and so on a date to be fixed by the registry. Before the none appears passed over.
In this case, the petitioner, who is a regular property terminal in the school, has not been paid his salary for a long time. And I filed this petition in May 23. And they were asked to obtain instruction in the matter.
Instruction is received, Your Lordship. We need to file our affidavit. Kindly grant us 3 weeks' time to file our affidavit.
Yes, Mr.
He's
Choli.
a TB patient.
You file it within 2 weeks.
Accept.
MSP Das, Learned Counsel for the Standing Council BTC submits that
Secondary education.
secondary education
Secondary.
submits that instructions have been received and she'd like to bring it on record by way of an affidavit. Mr. DP Cholia, Learned Senior Counsel appearing for the petitioner, submits that the affidavit ought to have been filed as the writ petition, as the petitioner is suffering from
Tuberculosis.
serious ailment. And his claim for salary with effect from 11/5/2017 has not yet been released. Let the matter.
The applicant before your lordship, he is a, my lord, senior lecturer under the different diets of the state of Assam. Now, my lord, selection process was initiated by the authorities. Pursuant to that, a DPC set, my lord, and the DPC duly recommended the case of the applicant along with others. Now, my lord, the writ petitioner filed the writ petition on the ground, relying on an NCT guideline that since we do not possess, my lord, PhD and do not have 55% marks in MS, therefore we are not eligible. And based on that plea, my lord, a coordinate bench of this honorable court was pleased to pass a stay order, saying that the selection process pursuant to the DPC minutes, nobody should be promoted. Now, my lord, already an interim order was passed. If your lordships will kindly come to, I'm not troubling on lordships on merit. On a special ground, my lord, order was passed. Please come to page 21, my lord, of IA 155.
Yes.
Please come to page 24.
Yeah.
I'm reading from para 3. Sri so-and-so learned senior counsel for the private respondents on the other hand raises the contention that the NCT regulation that the writ petitioner is relying upon is applicable only to those institutions where B.Ed degree is being undertaken, whereas institutes where the respondents are appointed as principal, they are imparting DL.Ed course and not B.Ed course. The aforesaid issue requires determination, but however it is stated that respondent number 6, Rajan Datta, would be retiring from service on 31/10/23, and therefore in the event if the determination is against the writ petitioner and said respondent number 6 is not allowed to take over charge of principal on being selected, he will suffer an irreparable loss which cannot be substituted later on. Consequently, the balance of convenience is also in favor of the respondent number 6. Accordingly, in the interim, it is provided that recommendation of DPC selecting respondent number 6, namely Rajan Datta, may be given effect to forthwith, and the joining of respondent number 6 shall be subject to outcome of the decision, meaning thereby that in the event this writ petition is dismissed, the joining of respondent number 6 would be construed to be a regular joining in the post. If otherwise, on the writ petition being allowed, appropriate order as per law would follow. My lord, without troubling your lordships on merit, the present applicant is retiring on, my lord, 30th April. And my lord, we apprehend, my lord, in the event of, declaration of the result, there will be model code of conduct. In which event, my lord, everything would be in limbo. So therefore, may I pray for a similar order only in respect of the present applicant, although as respondents were quite a few, mine.
No, this order was passed in which writ petition?
This is same writ petition in IA, same writ petition, my lord.
Now, how many posts are available?
There are 19.
19.
My lord, assuming the writ petition succeed, she will be entitled only one seat, my lord.
That's right. How many are filled up that way?
Now only one has been filled up by that order because he was retiring in October. Or that prior to that one was given and the present one is the third one.
Who's appearing for the petitioner?
My lord,
I'm appearing.
Ah.
My lord, this entire writ petition is, my lord, without going to the merits, my lord, entire writ petition is fixed on 15th of February, my lord, for final disposal because pleadings are over. So instead of passing any order in this IA, my lord, lordship can take up the entire writ petition on 15, my lord. Because this contingent, my lord, in the case of other person whose order has been read by my senior, he was about to retire on 31/10/2023, and this honorable court was pleased to pass an order on 13/10/2023, taking into consideration the contingency that he is retiring on 31/10. Here, my lord, we have got enough time.
No,
He
my
is
lord,
retiring on,
once,
he is
once
retiring
the,
on,
once the election notification.
When are you?
my lord,
when are you-
15th of February,
No, when are you retiring?
30th
April.
of April.
30th of April. So we have got enough time, my lord, 15 February.
My lord, even otherwise, my lord, they are relying on a notification.
My lord, that is
which
on merit.
apparently does not apply, that applies to B.Ed.
My lord, that is on merits of the case, my lord. I am not going into all these things, my lord. If your lordships want, I can, my lord, address your lordships on merit, but
No, no.
Ever-
The question is you are challenging what is your challenge in the writ petition?
Yes.
my lord, all these things were gone into by this honorable court on the last occasion. And after that, this order was passed that has been read before your lordships by my senior.
Hmm.
All those things were taken into consideration.
No, no. But
My
we
challenge,
want, yes, we want to
although
know your primary challenge in the petition.
I have challenged, my lord, the DPC minutes
My notes.
dated 7/7/2023.
So assuming,
My lord, what happened?
assuming you succeed,
Yes.
That issue is there, my lord.
assuming you succeed,
I am not on that. That issue is there. That out of 19 posts, I am entitled for one post.
no, no,
But
no. Assuming you you are challenging the DPC.
Yes, my lord.
Was your case recommended?
No.
Not recommended.
No, issue is not that, my lord.
Ah.
The issue in the writ petition is that the NCT regulation says that for holding the post of principal in a diet, you need to have PhD and MAd with 55% marks. All these respondents are underqualified, my lord. They don't have PhD.
Mr. Counsel,
I'm sorry.
assuming we allow your writ petition,
Yes.
can there be a direction to appoint you? No.
No,
The
then there
most
will
we
be
can do is to go for a review DPC
Yes.
that
to consider your case.
this DPC meeting dated 7. My lord, I am not on that. My simple contention is that, my lord, since the entire matter is fixed on 15th of February, my lord, why to pass some order here, my lord? Because entire matter can be heard and decided, my lord. So that irreparable loss and injury and all those things that was there in the earlier case is not here, my lord.
15th, Mr. Chaudhary, 15th of
My lord,
February.
my lord will kindly give me 5 minutes time, my lord. Why the writ petition deserves to be dismissed with court?
No, no, we
My
are
lord, in
we-
that even
no,
I'll
we are
address,
not-
my
we are
lord.
not
In that
taking
even
up the
I'll
writ
address.
petition.
My lord.
We are not taking up the writ petition. We are considering
I
on
was
I.
trying
The petitioner.
No, I was just trying to show, my lord,
Yeah.
they're relying on a notification which prescribe a qualification for B.Ed colleges. This is not B.Ed college. By placing that notification, my lord, they got an order.
My lord, this
Court prima facie believe that this notification is
My
applicable.
lord,
That
perhaps
notification is not applicable.
perhaps my senior is
Secondly,
not
my lord,
properly
they have
instructed.
not challenged the rules. The rules prescribed what we have possessed. Assam government has amended, my lord, but Assam government has applied the NCT regulation prospectively. They have not touched the post of principal. The intention of the Assam, but the government has filed an affidavit in this case long back.
All the pleadings are over, my lord.
No, my lord.
And this submission of my senior that, my lord, these institutes only, my lord, for delete, not B.Ed. My lord, that is incorrect, my lord. My senior is not properly instructed. I have, in my reply, annexed the documents which clearly shows all the diets, my lord, they impart delete as well as B.Ed, my lord. So my,
This
my
state's
humble
affidavit
prayer,
is very clear.
my humble prayer at this stage will be before your lordships that since the entire matter is fixed on 15 and your lordships on the last occasion recorded that, lordship will kindly have a look at the order dated so and so. I'm just last order. Passed in the writ petition, my lord.
No, my lord, what
You
my
are
learned
not a,
friend
you
will
are not a
get,
PhD.
supposing.
No,
my lord,
what?
Yeah.
No, I am not PhD, my
You're
lord.
not a
My
PhD.
lord,
It's
that
not
is,
PhD.
my lord, the rules that has been framed by the government of Assam that do not prescribe B.Ed, my lord. They have not challenged the rule.
You know, those things.
No, so why not take up the matter on 15th?
No, I'm not on that, my lord. Our only apprehension is, my lord, in the event election.
Before 15th.
Yes, my lord, it's quite possible. Ram Mandir is 22nd. Thereafter, we all know what is
Lordship
going to
will
happen.
kindly have a look at the order dated 10/1/24. Passed in the writ petition.
That we don't know, but.
The only thing is, my lord, no prejudice would be caused to the my learned friend's client,
No,
assuming
because-
she succeeds.
because.
But how can she stall the promotion of 19%?
Look, that aspect has already been gone into
My
in
lord,
the earlier round of
knows
litigation.
it is a elementary principle of
See,
service.
the interim order was granted on 28/7.
Yes.
With
Original order, my lord.
That is not to promote anyone.
Yes.
Without PhD.
Yes.
Now that, according to you, has been altered.
Altered.
In respect of respondent.
Only one respondent, because the respondent was retiring on 31st of October and their order was passed on 13/10.
And the
Here,
riders,
my lord,
riders given in para 5 of the order read by my senior, my lord, is explicit enough to demonstrate the importance of the issue, my lord. So many riders.
My lord,
Then 6 is also not a PhD holder.
No.
Then?
But since he was retiring, in that contingency, my lord, this honorable court passed this order. Here he is retiring in the month of April 15th. We are having the matter, my lord. If the applicants don't want to do the hearing on 15th, then
I'll definitely do the hearing.
No.
So that
The-
this
the-
petition
not
is
the-
dismissed.
What we want to know is
Yes.
your claim, assuming if there is any, it is to one post, number one.
My lord, I'll address.
Number two,
yes,
your prayer in the writ petition is a challenge to the minutes.
Yes, ma'am.
So assuming the writ petition is allowed,
yes,
the most the court can order is interfere and go for a review DPC. Holding your case, whether in the review DPC you are ultimately selected or not is another question at all.
my lord, if my writ petition is allowed, all the private respondents, they will be ineligible
Very
to
well.
hold the post of
Very well.
principal.
We'll make it subject.
So that is what I am saying, my lord.
We'll make it subject.
Lordship, then Lordship will have the matter on 15, my lord. You take up the
When is
matter
the matter fixed? Because it will not be proper for me to prepone the matter.
fixed on 15, my lord.
So you have a date earlier, you make a mention before the court, prepone it.
I don't have any problem before 15, my lord. On any date, your lordships can take up in the month of February, my lord. Because I made this submission because, my lord, he is retiring on April. We have got enough time.
And the order which has been given is made subject to the outcome of the writ petition.
My lord,
Assuming the process goes on and on 15 the writ petition is allowed, whatever process has.
I understand, my lord. I have also read the order, my lord.
That's
I understand
Then how
what
are
has
you
been read.
prejudiced?
But what I am submitting is that if I don't succeed in the writ petition, they will get everything in the month of February.
What I want to know is, have you gone in appeal against this order?
Which order, my lord?
This order?
No, I am not aggrieved by this order, my lord. I am not making a grievance against this order. But what my submission is that, my lord, since the matter is fixed on 15, if the matter is decided either ways, my lord, they'll get their thing because they're retiring in April, my lord. Then all the persons tomorrow will come and, my lord, get an order.
I see no difficulty there because they're entitled to only one
My lord,
post.
my humble submission is that since your lordship is in session of the matter, taking up the entire matter for hearing in the month of February 15, my lord, entire matter should be heard instead of, my lord, this, with all due respect, my lord, this
This is what we are asking you. This is an order which was passed inter party after hearing you. You have agreed.
My lord, the
Well,
situation.
this order has been passed
Situation in that case was different, my lord.
and it was passed in October.
It was in a different factual situation that order was passed because on my lord, in that particular
Whatever-
he was retiring.
Whatever circumstances, the respondent 6 according to you was not qualified.
Sorry, my lord.
Respondent 6 was not
That is
qualified.
according to me. That
Ah.
is what, but I am on a different context, my lord. My submission is that, my lord, either way, the decision comes on 15, the things will be once for all settled, my lord. So not to.
What is the stage of the promotions now?
No, my
Orders
lord,
have been
because of
issued.
this stay order, there it's held up.
No, have the orders been issued?
Yeah, in respect of the respondent number 6, it has been issued.
No, in respect of you, what is
No,
the
no, it's not been issued
no,
because there is a
no,
stay order is opening. That's
nobody
why
has been-
finally
no.
the IA, my lord. I waited. Now, because of the impending election and all, we all know that procedure, my lord.
That
No,
election
that is okay, but the matter is otherwise
So, my
fixed.
lord,
on
all that
the-
I was trying to submit for your lordship's kind consideration is what is the prejudice which my learned friend's client will suffer.
Prima facie, there appears to be none.
Then
prejudice is a different thing altogether, my lord. But the issue is why do, my lord, when we have fixed the matter, they also prayed, I also prayed, there is urgency in the matter. Let the matter be taken up on 15. My lord, why this? Since we have got time till April, what prejudice will cause to the applicant? My lord?
What prejudice is caused to you?
You know, he has come because he said that he
are-
had prejudice.
No, Mr. Counsel.
I'm sorry.
You have not objected to a similar order passed against a respondent
My lord,
who, according to you, is also not
that-
qualified.
In that event,
Now-
facts were different, my lord.
What are the difference?
My lord,
facts?
in that event, you also will kindly have a look.
He was retiring.
He was retiring.
On 31st.
There was no completion of the pleadings under that circumstances.
Yet-
He came. Since
The respondent 6, according to you, was not qualified. Did not have a PhD.
did not have a PhD.
So therefore was not qualified.
Yes.
Yet you agreed that
It was not a consent order, my lord.
may not be, but there
It
was
was
no
not a
appeal.
consent order. It was argued full length. Thereafter, hearing this honorable court passed this order with these riders in para 5. A reading of the riders in para 5 would give sufficient idea to your lordships, my lord, what the court appreciated on that day.
No, I think there's
So
no
that's why my lord
prejudice.
saying
I mean,
lordship will hear the entire matter since we have
We'll
got
hear
time.
it. We'll hear it. We'll make it subject to outcome of the writ petition.
Look, there is no requirement in my humble submission, my lord.
Ah.
Lord, with all due respect, my lord, since he is retiring in April, there is no requirement of presupposing his retirement in February, my lord. It is not necessary, my lord.
We have heard you.
My lord, that is, lordship will kindly appreciate that. All lordship will give me time to file objection in this IA, my lord.
All right, you file your objections. Then let him file his objections. We'll keep it next week.
Man.
Heard learned counsel for the parties issue notice returnable on
Lord, sometime, my lord.
just an objection you are filing. Have it on
People put it over in the
29th.
My lord,
Can we have it?
yes.
29th.
My lord, can it be on 31st, my lord?
31st is a holiday.
31st.
So, no, you want to file an objection, file it next
File
week.
it.
Let us have the
31st.
matter next week.
31st is 1 second, my lord.
31st is a holiday.
31st January, holiday. Then
And it's the 29th.
1st of February, my lord.
No, you file your objections, whether you file it by 29th.
Fine, my lord.
You file it
Lordship
by
will take
29th.
up on 1st of February.
We'll see whether we can take
If
it up.
required, my lord, I'll make a mention before your lordship. Lordship will take up the matter in the first week of February instead of 15.
What
I have-
difference? What difference does it make, Mr. Das?
Sir, I
We are
don't have
giving
any-
you an accommodation only because you are asking for it. Technically, this order doesn't appear to
My
prejudice
lord,
you.
I express my mind before your lordships that instead of
No, you're
going into
right.
this,
You're right, but what prevents the court from passing a similar order? This is an order in favor of a respondent 6 who, according
lord,
to you, was
in
not
my-
qualified.
I again reiterate, subject to my lord permission, that he is not similarly situated.
That's right.
Well, and I'm absolutely similarly situated. Government affidavit was
Heard.
there on the court's record on that day.
Is heard, learned
On merits, my
Mr.
lord, I
K. N.
address-
Chaudhary, learned senior counsel assisted by Mr. R. A. Chaudhary. For the applicant, Mr. H.K. Das, for the opposite party writ petitioner. Anyone else?
For report number 8 to 14,
Mr. Nayak for respondent?
Yeah.
For?
SCR team.
SCRT. And Mr.
S. Hazarika,
For?
number 8.
Respondent number 8 to 14, private respondents. S. Hazarika, Mr. Khatoniar for? Respondent 1. Let notice be issued returnable on 29th of January. Objections, if any, may be filed. Matter be listed again on
My lord, may I
29th.
pray, on that day, Lordship will also go into the aspect of maintainability of the writ petition because the petitioner is not in the zone of consideration.
We'll look
My lord,
into
Yes,
it.
that issue may be kept open.
My lord, in fact, on 29th, the entire matter can be heard. On 29th, if you are
Not in the zone of consideration.
We'll see about it.
entire matter can be heard, my lord. On 29th. Deeply okay.
Along with the Yes.
In the morning, they have stated that as per instruction, no review has been made as of today.
Yes.
Well, my instruction is, my lord, show cause notice was issued to him on 8th January, my lord.
Hmm.
But review has not been done till
So
date.
review not done, so you'll reinstate him. Or you want us to set aside?
In fact, my instruction regarding the review, my lord, they say that it is in process, my lord, but it is
What
telephoning
process?
instruction.
It has not been done.
It has not been done, my lord.
It has not been done. But you have not filed your affidavit or anything like that.
No, my lord.
You bring it on record.
Yes, my lord.
We'll give you 1 week time.
Yes, my lord.
Let us have it on record that there is no review.
His instruction is clear, your lordship.
Oh, his instructions are clear, but
On the last date also, they have stated that there is no review, your lordship.
you bring it on record or you produce the relevant records.
I'll bring it on record, my lord.
But it must be done within 1 week.
Yes, my lord.
Mr. Khatoniar, learned standing council, education is permitted 2 weeks further, 1 week's further time to complete his instructions and file necessary affidavit with regard to the status of any review being conducted regarding the continuation of suspension of the petitioner. Matter be listed on 30 January.
Obliged.
Mr. Amit Lashkar appears for the petitioner.
In the meantime, if they extend, your lordship, it will be of no consequence.
Uh-huh.
In the meantime, if they extend, it will be of no consequence.
We don't know, we'll see. Yes.
May I please, well, here, my lord, petitioner before lordship was the headmaster of a primary school, my lord, who retired on, my lord, 28 to 2018, my lord. Prior retirement, my lord, he completed 30 years of service, my lord. There is government notification, my lord, on 30/10/2019 and 7/2/2020, my lord. Whereby, my lord, 3%, my lord, increment at the rate of 3% increment was allowed on their basic pay who has completed the 30 years of service. My lord.
Okay, heard. Mr. Learned Council issue notice returnable 4 weeks. Mr. P. Soikia appears for pension.
4 and 7, my lord.
4 and 7. Mr. Khatuniar for education department, elementary. And who's for finance? Mr. Solia for finance department. Since learned councils have entered appearances, notices are waived. However, extra copies be furnished within 1 week from today. List after the returnable date. Yes.
Here, my lord, item 30, EP order has been issued, my lord.
Huh?
EP order has been issued, my lord.
In respect of petitioner 9.
My lord. Not on petitioner 9, my lord.
That is his case. 1 to 8 have been given.
Yes,
9 has not been granted.
My lord. Only, my lord, They have sent instruction that all petitioner, my lord, but specific to 9, my lord, I have to take instruction. Just today I take the instruction from the department.
You get it? Let us have it on 24th. Matter be listed again on 24th, enabling the standing council pension to obtain instructions as to whether
Petitioner number
pension
9.
has been issued, granted to the petitioner number 9, as the petitioners 1 to 8 have already been granted their pension.
Petitioner number 9 is, my lord, not available in my petition, my lord.
Huh?
There is no 9, only 8 petitioner is there, my lord.
Lordship, initially I have furnished the 2 extra copy lots.
Huh?
2 extra copy already furnished, Lordship.
No, he's not saying that. He says your petitioner 9 is not reflected in
Yes,
the post
my lord.
titles.
So that's why the fresh copy I have carved lots already 2 times. Another council was there, Lordship.
What another council?
Yes, Lordship. So I think I'm friend junior maybe. So I don't know the her name, Lordship, that. Yes, I'll find.
I'm appearing for respondent 1 and 2.
MSP does for respondent 1 and 2. Mr. M. Gogoi for respondent number 9. Anyone for accountant general?
Yes, yes. 30. 30.
Mr. Talukdar for accountant general. Yes, all right. List on 23rd.
May I please, your lordship? Lordship, sorry for the inconvenience. Lordship, in the cause list, our name is not reflected. That is why, lordship, we miss this matter. And lordship, Mr. Somo is out of station. Lordship, any date next week?
We'll give you date provided you tell us what are the UGC rules in respect of recognition of PhD. State government says that because the PhD has been done from outside the state, it is not recognized.
Lordship, as per his instruction, lordship, after 2009, the recognition of Singhania University withdrawn, lordship.
You give us the detail.
Lordship.
And when did they obtain the PhD? When did you get your PhD?
Lordship, 2013.
2013.
13.
Yes, my lord.
And his degree is invalid, lordship.
So you furnish that
Lordship,
required.
next date,
Next date. So
But my lord, the affidavit filed by the UGC, there is no mention.
Where is the affidavit filed by the UGC?
In item 37, my lord.
37.
Yes, my lord.
You have you don't have the file. You have.
lordship.
Please
We
read
will
your
file
affidavit.
additional affidavit, lordship.
Huh?
We will file additional affidavit.
Sorry?
We will file additional affidavit, lordship.
No, but whatever affidavit,
Lordship,
additional
it's not
affidavit.
mentioned, lordship.
Additional affidavit.
Lordship.
Who has filed additional affidavit?
Lordship. Lordship, I will file.
No, you will file, but
Lordship.
we want to know.
Respondent number 5, lordship.
Yes, respondent 5 has already filed a counter affidavit. Do you have a
Lordship,
copy?
Yes, lordship. But this thing is not mentioned in this affidavit, lordship.
We were unable to understand what you wanted to say in your affidavit. Doesn't reflect anything.
Lordship. Lordship, that is why we file additional affidavit, lordship.
It is very clear, my lord, as per UGC Act 1956, and it is rule, my lord, regulation 2010, that eligibility criteria of assistant professor, which is also annexed with the affidavit. Last page, annexer A.
But lordship, if degree is after 2009, university is
You produce that circular.
lordship, next that we will produce, lordship.
When? 23?
Lordship.
List on 23 at the request of MS so-and-so Learned Standing Council, UGC.
Lordship.
who undertakes to produce the circular whereby the Singhania University, from which the petitioners completed their PhD, has been derecognized by the UGC. Let the matter be listed again on 23rd. Mr. Ahmed for the petitioner, MS Sarma Hazarika for
PR Mohanto.
PR Mohanto, sorry, for
Phone number
respondent number 2. Mr. SK Das for 4. Yes.
Lordship, can we
23rd.
reflect our name, Lordship.
Huh?
Reflect our name in the cause list, Lordship.
Registry to reflect names of all councils, including standing councils, UGC, in the cause list. Copy of this order we brought to the notice of Registrar Judicial. Joint Registrar Judicial. Yes. Yes.
My lords, their entire matter hinges on, my lord, one particular aspect. My lord, whether the chief engineer or the executive engineer, my lords, can they grant regularization, my lords? That too also, my lord, on the eve of their retirement date, my lords, without the concurrence of the finance department. Is the authority, the executive engineer or the chief engineer as the authority without the concurrence of the finance department, as who are the Upendra's directions, my lords, if they are eligible for this kind of regulation and consequent benefits, my lords?
What steps have you taken against these officers who granted regularization?
Some have retired, my lords, and it came to light very lately to us, my lords. And my lords, we have received our parawise also. If lordship gives an observation that they are the competent authority to grant regularization, nothing survives, my lords. We like to file an affidavit, my lords.
No, we were not stopping you, but it was not
Yes,
by.
yes, because I have to disown, my lord. I have to disown my executive engineer. I have to disown my chief engineer also.
But then you'll have to tell us what steps have you taken if they have.
That I have to, my lord. I have to take my lord instructions.
No, if they have issued orders which are
Yes,
beyond
yes,
their
yes, yes,
competence.
yes. They have to face the music, my lord, which is contrary to the law, my lord. I'm not defending anyone, my lord, but lordship will grant us one chance. I have to take some instruction whether something is going on, and because everything has to be returned by the finance department. Lordship need not take trouble of going to other. Their synopsis is itself very clear that some exercise called ex post facto approval, that too on the eve of their retirement.
Apart from that, my lord, there is office memorandum of the government of Assam, my lord, which says if any temporary employee serves for 20 years and the service is in the nature of substantive, then he is entitled to continue.
Which office memorandum?
Memorandum, my lord, it is in this book, page number 190.
Dated? What is the date?
Date, my lord, 6 September 2003. Page number 190. And it was issued in continuation of the another office memorandum that was 12th September 1996.
Then I have a judgment of 2023, February 8. If they don't fulfill two principles enunciated, my lords, with Umadevi, my lords, they are not entitled for any kind of regulation.
We are not asking for any regulation.
They are asking for pension.
Asking for
Not for
Pension, no, my lord. That is the catch, my lord. Though they say they don't want regulation, but they want benefits of regulation, which is regular pension. At this point of time,
this office memorandum, has it been withdrawn?
No, my lord.
It's not withdrawn, my lord. But there's a judgment of this honorable court, my lord, Sanjita Roy, which seeks, my lord, if regulation, a person is entitled to a proportionate pension, which doesn't amount to regular pension. There are two modes of pension. One is proportionate pension, one is regular pension.
We have completed.
What have you given them?
My lords?
What have you given them?
They are regular people as per, my lords, this Upendas. They will definitely get some pensions which are proportionate to their work done. It doesn't amount to regular pension, which is given to a permanent post holder, my lords.
We have served in the department for more than 30 years, my lord, in a regular scale of pay. We have been given the benefit of ROP. We have been given the EB crossing benefit and everything. annual increment, everything.
Now,
Revised pay
at
scale.
this later point in time, you come and say that your officers had issued orders beyond their competence.
Yes, my lord. I have to say because what is wrong, my lord.
No,
So I have to
what
file an
what
affidavit.
is wrong, but then it is not their fault.
My
It
lord,
is not their fault.
It's not their fault, but they also cannot take benefit of a fault.
They have to.
No, my lord, if
because you
there
have-
is
you have
any
extracted
illegality
work.
committed, if is any illegality is committed in giving such benefits to other
Illi-
person, they also cannot take benefit of such illegality, my lord.
Correct. But then if the
So-
illegality is of such nature
Yes.
that the department has closed its eyes for a long time,
No, it's not a long time.
Then-
It's not long time.
and then
It's
no,
just- it's
no,
the-
no
this- well, this
sufficient
brings the stuff
material
into-
is there
Yes, my
to
lord.
show that steps have been taken to
No, steps, my lord, these papers are
correct these
forward-
illegalities.
Yes, my lord.
Why
This-
at this stage we will
Uh,
entertain your
my lord, we'll file
submission?
an affidavit, my lord, because this has come to surface last 2 years, these are happening. And
When
although
did you-
only from this division.
When
my lord,
did you
this is
receive
Haila-
your instructions?
this is Hailakandi.
When did you receive your instructions?
Instructions were from my lords. Well, these are of 23. One of 22. My lord, there was a batch. And my lords, and one is of 21.
So you tell us when you want to file your affidavit.
My lord will give us 3 weeks, my lord, a fixed date.
No, give us a date. You give us a date by which time you want to file. We'll fix the matter according to.
My lord, kindly fix this method in on. Let us go by him. Then.
No, we want to. You are filing the affidavit.
Yes, man. Then let it.
If you want, we'll fix a date.
Let it come on 4th of March, madam.
4th of March.
March.
No, why
2nd
not
of March.
after April?
2nd of March.
Why not after April?
I'd like to. Then in February, madam. February 23.
Matter will
23,
listed on
February 23.
19th of February.
My lords.
As it is submitted that the respondents have completed their instructions, they're expected to file the affidavit. Mr. Purukaister appears for the petitioner. It is submitted, it is made clear that if no affidavit is filed by the date fixed, the court may proceed to hear the matter on the basis of the pleadings available on record. Mr. D. Gogoi for the petitioner, for the respondent. Which department is it?
PhD, madam.
PhD.
Always, madam.
Mr. Radhor for accountant. Accountant general. Yes.
May it please, your lordship. In this case, petitioner retired on 30.
Any instructions?
22, lordship.
Lordship, the latest instruction is that Director of Pension return back the pension papers as there was, they found out that there was overdrawal of salary to refix it and resubmit. Accordingly, the inspector of school, Lordship Chirang, wrote to the principal to to take the necessary steps and submit the statement. That was done on Lordship 22nd December. Till date, there no further progress is there, Lordship.
Who is supposed to do that? Respondent 7.
Respond number
seven.
Who's appearing?
I'm appearing.
So what have you done?
My lord, initially we have submitted, but it has received late for having instructions, my lord. It's on that part. Because on July 2022, we have initially submitted these pension papers forwarded. It has come back on December last year, my lord. December, one take it. One take it.
December
22nd of December. So we'll obtain instructions, my lord.
Mr. Chaudhary appears for BTC.
Yes, my lord.
May it please, your lordship, petitioner has not yet received their arrear salary also, lordship. In this regard, lordship kindly pays honorable court order dated 21/8/2023, lordship. On, so, may I read, lordship? last para. On the next date fixed, the respondent authorities in the BTC shall apprise the court about the status of payment of arrear salary payable to the petitioner, as the BTC authorities in earlier occasion placed before the court that the proposal for supplementary budgetary allocation towards the payment of salary to the petitioner was already sent to 7/10/2022 and shall also apprise the court as to when such arrear salary payable to the petitioner was made available to her lord. And he has received her provisional pension also, lordship.
Okay, provisional pension. What has been done?
Lordship, that is still under consideration now with the deficiency to correct the mistake, Lordship, as submitted by the Director of Pension, Lordship, that has to be again recalculated, Lordship.
Provisional pension gratuity, lordship, nothing. Yes, yes, yes,
MSR Decca appears for the petitioner, Mr. B. Chaudhary, learned counsel appears for the PTC, who submits that the pension papers which were submitted have been returned back to pension papers which were submitted reveal that there was excess drawal by the petitioner, and particulars thereof have been called for in respect of the excess drawal statement from the principal of the concerned school, namely Principal Pijni Bandhop Higher Secondary School, Respondent 7. Mr. Boro, learned counsel, appearing for the Respondent 7, submits that he's awaiting his instructions in this matter. Let the matter be listed. You are appearing for secondary. MSP Das for secondary education. The matter be listed after 2 weeks. Stop. It is, however, directed that in terms of the earlier order passed by this court on Twenty-one eight. 21 8.
21/8.
The BTC authorities were to apprise the court in respect of release of provisional pension to the petitioner. However, the same not having been done, the directions of this court be complied with by the petitioner, by the respondent BTC authorities, and expeditiously process the pension papers, and in the meanwhile also consider the release of the provisional pension in respect of the petitioner by the next date fixed. List again on 19th of February.
Okay.
Hello,
Yes. What are these matters?
May it please, my lord. My lord, item in this series matter, my lord, item number 98, my lord. If my lord would kindly come to order dated 14/11 passed by this honorable court. My matter was segregated, my lord. It was directed by this honorable court to segregate my matter and file a separate affidavit, as affidavit was not filed in my case. Till date, it has not been filed, my lord.
2067.
2076, my lord.
76 is to be segregated.
It needs to be segregated and an affidavit was supposed to be filed, but it has not been, my lord, till date.
All right. In WPC 2076 you take in view of the order passed by the court earlier in this batch of writ petitions on 14/11/2023, WPC 2076/2023 is required to be segregated. Registry to ensure that this writ petition is not listed as a part of these bunch of writ petitions. Liberty is granted to the respondents to complete their instructions and file their necessary affidavit if so advised. Matter be listed separately after 2 weeks. Copy of this order we brought to the notice of the registrar and judicial. Yes,
If it pleases my lord, the date may be clarified.
let them file their affidavit. You make a mention later.
My lord.
Yes. Now,
Here, probably, my lord, I'm ready for hearing, but my colleagues, probably they have not filed their reply. Already in my part, I have already filed a reply. And my colleagues, they are supposed to file their reply or all these things, they will say.
what is the matter about? What are
This
these?
regarding probationary appointment, my lord, regarding the issue, my lord, it depends on case to case, my lord. Every
Then
issue
why are they connected?
I do not know, my lord. Compassionate appointment, every cases have been tagged, my lord.
They are compassionate appointments.
Lordship. And some cases, my lord, here the DLC rejected, in some cases SLC rejected. In various grounds, my lord, and the petitioners came before lordships. And in similarly situated, in my case, similarly situated persons already been, their cases have been considered by SLC.
Who appears in WPC 5086?
So number one is my. I'm concerned only 5086.
Now they say there is no vacancy.
No.
In your case,
The my lord, in my case, they have said something else, my lord, sir.
5086
Yes.
is your matter.
Yes. It is said that non-availability
No vacancies.
of vacancies as per roster register. On the same point, already this honorable court has decided. There are so many cases, my lord. And on the basis of that, my lord, on the same DLC rejection letter, on the same way they approached this honorable court and they got the relief, my lord.
Where is that order?
I have also enclosed one of the order I have enclosed in writ petition, my lord.
Page number?
Page number 51, lord.
Para 15. You are with regard to para 15.
Lordship.
But that has been examined when there is no vacancy.
No, that case, my lord, already that has been referred to the government, my lord, and the government has already considered. Whereby, similarly, their initial case was rejected by the SLC on the basis of that non-availability of the roster vacancy. The ground was sent, but that case has been considered by the SLC in the subsequent stage, my lord, in terms of the honorable court's order. And other judgments are also there, my lord. 3-4 judgments are also there of this honorable court.
No, you are aggrieved by the report.
Now, my lord, in this case, they have filed affidavit by enclosing one report, whereby in each and every cases, the report has been enclosed, my lord, stating the fact that why it has been rejected, that part. And that part, in the same way, if in other cases, this honorable court has decided, similarly, the petitioner cannot be deprived and denied the same direction. an order, my lord.
Each case has been decided.
Yes, my lord,
Non-availability.
since this provision, this 15, clause 15 is there if the vacancies are not available in the particular department, then clause 15 will be applicable, and accordingly this court directed the authorities concerned to consider the case of the petitioner under clause 15 of the OM 16/2015. Now, my lord, apart from having all this the vacancy problem, now we have come to know one notification has been issued advertising the 5,000 posts, my lord, for grade 4 employee. That part is also required to be placed before lordship. That has been already placed before this honorable court in some other case, my lord. Already government has advertised. If the clause 15 is there, my lord, to fill up the post, then why advertisement has been made? And if that advertisement has been made, then firstly these court cases, whatever the pending matters are there, as per the direction of the honorable court, that has to be considered. One way they are saying that vacancies are there, they are advertising the post, and another way they are saying that this one way 5% reservation, another way again roster policy. I do not comment. And
Is the roster required to be maintained for?
Roster for this 5%.
5%.
Huh?
Well, all the posts are not meant for to be filled
Only
up. by-
5%.
Yes. So that is the roster.
So in the 5% again, you maintain a roster? No.
They are saying that there is as per roster. And the fact remains that if a person comes after 10 years, 20 years, as the recent judgment of Tiwari, what is that? Debabrata Tiwari has taken care of all these things, my lord. Whether a person after coming after so many years would be entitled to compensation appointment or not. It's a
Whether he survive.
whether the cause of action survives after so many years.
This
or
is
not.
your first writ petition.
this second time, my lord. No, against the SLC is the first.
My submission, my lord, individually, this case, Lordship is hearing, other cases, he himself is saying that affidavit has not been filed. Lordship, my submission will be like this, my lord. If all the matters are tagged and to be taken up together, then some certain common issues are to be framed, what are to be decided. Now, individually, if your Lordship decides, then there is no requirement of tagging the matter and hearing the matter collectively. If your Lordship is hearing the individual cases. Otherwise, my lord, if all the petitions are to be taken up together, then after if they do not want to file affidavit, it is all right. If they want to file affidavit, they let them file. And then certain common issues are to be found out so that once those issues are decided by your Lordship, based on the decision of your Lordship, all the cases can be disposed of. That should, in my humble submission, should be the approach.
Whatever my learned friend is saying, I agree to that, but problem will arise, madam. Since in each and every cases, madam, the issue is different.
In that view, there is no question of tagging.
If it is
Cases don't
taken up,
tag.
my lord, every case has to be heard by your lordship. And
No, we will hear all cases. We'll hear all counsels. There's no problem there.
Yes,
But essentially, it is a case for
compassionate appointment.
compassionate appointment.
That's true.
And compassionate appointment is guided by the office memorandum.
Yes,
So
and office memorandum says that if there in the post in the department there is
read with other parameters.
no vacancy, then clause 15 will be applicable as per the office memorandum.
And in view of one or two clauses, if an order is passed in the vacuum without ascertaining as to whether he is, first of all, he is entitled or not after so many years, and secondly, even in that department, whether there is any vacancy or not.
No, but these will have to be raised by the respondents also. You'll have to raise these objections. You have filed a common affidavit.
That's what I'm saying, my lord. That's what I'm saying, my lord. If all the cases are taken up together collectively for deciding by common judgment, then certain common issues are to be found out first.
That's right.
If there is no common issue, then individually lordship will take up the cases. There is no difficulty, my lord.
According to them, besides the fact that it is a compassionate appointment,
my lord,
the grounds are different.
That's what I'm saying, my lord. If the grounds are different, then there is no question of hearing these matters collectively. then individual cases may be listed and individual cases will be
That's
disposed
true,
of.
my lord. Individually may be hard.
I leave it to your lordship, my lord. It's for them to take the
Because
call.
every cases are different, my lord. And it will be a very toughest work to pass a common order because everybody's issue is different.
No, my lord, question is my lord, whether there is any requirement of deciding any common issue or not first.
Why
they-
don't which department are they? Why doesn't your
Different,
government
various-
advocate,
various
Different department.
No,
I am
you-
for the veterinary.
as a government advocate,
My lord.
you find out what are the grounds here in each writ petition vis-a-vis. Then we will decide whether there are common issues or not.
My lord, we have filed a common affidavit and in this affidavit, my lord, we have dealt with each cases.
Is it?
Yes, my lord.
Affidavit filed by?
Filed by the chief secretary, my lord. Here,
No, personal department.
personal department, my lord, on behalf of the chief secretary, my lord.
Personally, not a party.
Personal department. Okay.
Some kind of personal department, your lordship, not a party, your lordship.
Hmm. So you have filed a common affidavit.
My lord, let me read, my lord, what the affidavit says.
Huh?
That I'm presently serving as a secretary to the government Assam personal department, and that the chief secretary of government Assam has been implemented as respect number 2. So, my lord, here, personal department secretary is filing this affidavit on behalf of the chief secretary, my lord.
Hmm.
Meaning thereby, chief secretary has filed this affidavit, my lord.
All right. Very good. Now, what
And-
is the content of the affidavit?
Content, my lord, we have dealt with each cases.
Show us.
My lord will,
Yeah, my lord, lordship will kindly go to a report, my lord. That report.
No. We are concerned with the affidavit. He says each case has
My
been
lord,
dealt with.
my lord, this report is a part of the affidavit, and here we have dealt with each and every case separately,
No.
individually.
Of course.
Yeah.
So that is what we want to say,
My lord.
that this report is under challenge in all the writ petitions.
No, not
No,
this
no,
report.
no.
No.
Not all
No,
the writ petitions.
No.
Then?
This is subsequent to the filing of the writ petition. Their cases were examined, and then this is
Each of the writ petitions.
Yes, my lord.
there is a committee.
And the committee has taken up this issue, my lord, individually.
So in the first writ petition, it is non-availability of vacancies.
Yes.
Then 2 years lapsed.
Yes.
Pending.
My lord, yes. Page 60, lordship will find the response to the first writ petition. Page 60, my lord. And in the second table, my lord, under the caption findings stroke observations, grounds on which decision is taken by the SLC or DLC. DLC dated 19/8/2015 quoted the loan applicant Mr. So-and-so has been recommended for grade 4 post. SLC dated so-and-so quoted ground of rejection non-availability of vacancy as per roster register. Then OM applicable dated 20th of December 2012. Annexes DLC minus dated so-and-so, SLC minus dated so-and-so. And observations of the committee, SLC rejection seems to be in order. So this year, my lord, in response to...
Have you received the affidavit? You have all received the
Yes, I have
affidavit.
got the affidavit.
Now, the affidavit includes a report. Have you gone through the report?
Yes.
Are your cases dealt with in the report?
Yes, as per the report, in my case, I'm saying, my lord, as per the affidavit and the report, my lord, I have filed my reply. And in some of the colleagues, my lord, they did not file any affidavit in reply, my lord. That is why probably they need some time.
Yes,
And probably they will
file affidavit, your lordship. Reply.
And if you're otherwise, lordship,
My suggestion will be like this. Lordship will give them, if they want to file reply, Lordship will give them a time frame within which all of them should file the reply, so that on the next day it can be taken up for consideration, final disposal.
No, that is okay. We'll give you time to file. But what we want to know is, essentially, your cases have been dealt with. Your cases have been dealt with by the government.
Dealt with, my lord, in similar way, my lord, in other cases also dealt with in the same way. whereas I have given the reply, my lord, categorically, my lord, whether this the ground of rejection, non-availability of vacancy as per roster register, whether all these are tenable or not, and whether the clause 15 will come in the field or not. Since in other cases on the same ground,
Who is to apply the clause 15? Who decides?
government, the SLC.
SLC.
In some cases, my lord, where DLC has rejected, DLC has to apply. And in where SLC has rejected, the SLC has to apply.
All
This
right.
is the
Now the applications for a compulsory appointment has gone to such an extent that in each and every department there is no additional post to accommodate a person from another department.
But this compassionate appointment is on the basis of what? There is a statute. Any rules?
No, there is no statute.
This scheme has been framed by this honorable court, my lord.
Scheme, my lord, in the form of an OM. Scheme in the form of this OM, and plus, in addition to that, my lord, the judicial precedents.
But there is no decision taken by the government to the contrary. As on date.
2017 we have done a with compassionate appointment.
And
No, now
I remember Lordship.
my lord, after 2017, there is no question of any compassionate appointment.
Compassionate pension.
Pension, now pension.
No, you confirm.
Okay. Let the petitioners file their respective rejoinder affidavits, if so permitted, if so advised. And the matter be listed thereafter. The respondents have already filed their affidavits. Respondents in the personnel and
Personal
department has filed an affidavit which is common to all the writ petitions. The said affidavit encloses a report of the committee constituted by the Chief Secretary. What is the date of the report?
Report date is
There is no date.
report date is 11/8/2023, your lord. 11/8/2023.
No, 11/8 is the date of constitution of the committee.
Report of the committee.
DLCL.
Yes, the report of the
DLC.
committee. Oh, sorry. Sorry.
3/8/2010.
In the said report, all the cases of the writ petitioners have been individually considered. Accordingly, let the matter be listed after 3 weeks, enabling the respondents to file their
Yes,
rejoinder
31/8.
affidavits.
31/8. It has been signed as 31/8.
31/8, 2020.
3.
31/8/23, report dated 31/8/23.
Your lordship, I have 2 matters. 70, it has been reported. I am going to file affidavit. But in item number 98, there is nothing against me in the report.
We don't know, you file it.
Yeah.
If
And
you
no
want, you
affidavit
file.
has been served in 98, your lordship.
Have you received a copy of the
No, in
affidavit?
98 I have not received.
My lord,
No, in the earlier, have you received a copy of the affidavit?
No, in 98 item, I have not received.
So in 98, is there any reference to your writ petition in 98?
In the
Some
common affidavit,
petitions which
but
were
in
not
the
taken.
report, there is nothing against me. That has not been clubbed.
Is there anything, what is 98? Let us see.
98. WBC 3501/2023. It is Kakumuni Bhuya.
So is there any reference to the petitioner in the report?
Only, no, nothing.
Nothing, then very well.
But they have filed an affidavit against this also, this item also.
They filed, you reply, that is what we are giving you time, Mr. Counsel. What you want to say in your rejoinder affidavit,
fact, there is
we are not
nothing
supposed to
against
tell you.
Nothing
Whatever
against-
you want to submit, you submit.
Reply quickly.
Nothing against me.
Nothing against you. So we are not disposing of your case, taking it out of the bunch. We are hearing the matter
All right.
as and when the rejoinders are completed. All right. After 3 weeks.
But the lordship is fixing or not fixing?
Let the affidavit be filed first.
Yes.
my lord. Let
Not
it-
fixing because unless you file your affidavit individually, we can't go on giving you time.
My lord.
These are all 19 matters, 17, 19 matters.
My lord, affidavit filed by the government, page 68 not received, my lord. Affidavit filed by the government, page 68 not received, my lord. Where my name is.
I'm sorry. Item number
Item number 73, my lord.
73.
Serious matter, my lord.
What has happened?
My lord, affidavit filed by the government, page 68. I have not received, my lord. Where
You
my
are supposed to give an email.
All my lord, whoever has given email,
Give
maybe.
your email.
68 missing, my lord. 68 missing, my lord.
Huh?
I got through email, my lord, but 68 not.
68.
Page 68.
My lord, everybody got, my lord, it's a common mail.
You recheck, find out if it is not served, you give it.
My lord, we have sent a common mail, my lord. Everybody has got it, only one page.
We are asking you to recheck. If it is not delivered, it will come back.
Others already I checked, my lord, they have not received.
You forget about others, you tell me about yourself. You are here before the court. What is your item number filed to the
73, my lord.
73. Yes. You have not received the affidavit.
Only page, my lord, 68. my lord.
Huh? One page you have not received.
My lord,
Okay, you take it, Mr. Counsel will give it to
my
you.
lord, 68